Morning, ladies and gentlemen. This is the June 5th criminal motions calendar at 10 a.m. for Judge Tammy Long Hayward in courtroom 304, State Court of Clayton County. First thing is for those of you who are on the computer screen, if you're coming in by video, I need you to change your name. If your first and last name are not on the screen, I need you to put your first and last name on the screen. I see a computer designation. Somebody has a Lenovo, somebody has an iPhone, but I need you to rename yourself so that we can have your first and last name. Because if I don't know who you are, it may be hard to place you. If you're having technical difficulties when I call the calendar, you may get a bench warrant. So please put your first and last name on the screen.
Okay, now how do you do this, ma'am? I'm trying to figure out how to do it. The guy was telling me there's 3 dots. I went to the 3 dots where it says more.
What's your name?
Oh no, go to app or something. Oh no, that's not right.
What's your name, ma'am?
Personalize your experience. Sign in. Sign in will.
Ma'am.
Yes, ma'am.
What's your name?
Latoya Ware. Okay.
All right, ladies and gentlemen, the first name on the calendar is Blankumson. Are we still going forward with the motion to suppress for Blankumson?
Your Honor, this is Attorney Corey Washington for Mr. Blankumson. He's 3 minutes out. We've reached an agreement with the state on the case, so it'll be at a conclusion this morning.
Okay, thank you. All right, next on the calendar is Michael Thomas Brasfield. Sharice Challenger is the attorney.
Yeah. Can you hear me?
Michael Thomas Brasfield.
Yes, ma'am. Can you hear me?
All right, Mr. Brasfield. So once again, if you are not sure how to change your name on the computer, go to activate the screen where you should be. And you should see 3 dots in a 3 white dots in a blue box. Click on that. When you see the pull down menu, you'll see rename. Click on that. And once you see the box open, put your first and last name in the box and hit change. And that will put your first and last name on the calendar. Okay.
I don't want to see that. Not.
All right. Has anyone heard from Ms. Challenger?
Your Honor, I've heard from Ms. Challenger. I negotiated a plea with Ms. Challenger that Mr. Brasfield was supposed to enter today. I assume that Ms. Challenger will be on the Zoom call shortly.
Okay, thank you. All right, next is Raymond Gomillion. That case was closed, but we do have a restitution hearing.
Yes, Your Honor, and good morning, Your Honor. In this case, the state is withdrawing that restitution hearing.
All right, for Gomillion, the restitution hearing has been withdrawn.
Thank you, Your Honor.
Any persons here for that restitution hearing are excused at this time. Jemiah Bethany Greer.
Your Honor, that case was reset to the next motions calendar.
All right. After that is Donnie Harris. Donnie Harris.
Judge, we have 2 Donnie Harris cases,
Oh, yeah. 2 Donnie Harris cases, 2 different attorneys on the Donnie Harris cases. Are we sure there's not 3? There's just 2?
There's 2.
Okay.
Got the one, Your Honor, that ends in 1091.
okay,
And Your Honor, the state's going to move to have that motion dismissed. The motion was untimely. Counsel filed into this case on 4/7 of 22. The criminal arraignment was 9/5 of 24. Then a separate arraignment was on 10/31 of 24. The time for motions to be filed expired on November 11th, since the 10th fell on a Sunday. And the motion was filed on the 30th of last month, more than 6 months after the due date for the motion to be filed.
And Judge, this is a very old case. I came on in 2022. And I don't disagree necessarily with the state. However, I am still waiting on discovery to be completed. So as the discovery rolls in, I've been filing motions to deal with what I have in hand. So,
what are you missing, sir?
I'm missing the Officer L. Jones from Lovejoy. He came after the stop and he did the HGN, the one-legged walk and turn, one-leg stand. So I've asked for those body cams, his dash cam, his narrative, and Ms. Hagler was going to get that to me. I don't know when y'all traded solicitors, but I haven't received it to date. So I would, once I get that, I'll be filing some more motions. Whether they'll be heard or not, I'm not sure, but.
And Your Honor, I'm not sure if Mr. Tipton has this information in the courtroom because we just received it from our legal assistant. So am I able to address that issue of discovery before the court?
Yes.
Okay, thank you, Your Honor. The state has provided counsel with everything that we've had. We've provided full discovery, January the 13th, 2025. If there was video, counsel would have needed to schedule an appointment to view it and not wait until June. Two, if it was not any video, he would not have received everything. So everything that the state possession, whether if it's video, reports, body cams, we have provided that to counsel. If counsel has not received video, either one of two things. One, we did not have it to be able to provide. And then two, and if we do have it, he would have had to schedule an appointment. So he has had discovery for 5 months before a motion was filed last week.
Well, Judge, and I have asked for video for every time I've been in court here. Ms. Hagler and I discussed that, and I brought it up to Your Honor.
Have you ever walked down the hall and gone to ask to see the video?
Yes, I have the video on Officer Hunter, the stop officer. It's Officer Jones that I do not, and it's
Okay, are we sure there is an Officer Jones video?
It's
And Your Honor,
police department. It says see Officer Jones's video. And
Your Honor, he did have an appointment with our office to retrieve video. There was a link sent. He saved the link, and this appointment was in April.
I have that video. I have that video.
I'm sorry, sir. I was addressing the court. Thank you. And so with that, Your Honor, he received that April the 1st, 2025. If he received all the video that we've had, Your Honor, so if he did not receive from another officer, I know he indicated Officer Jones or whomever is the other officer, that means that we do not have that video because we would have provided at his April the 1st video appointment date.
Okay, and I understand that if there's no video, there's no video. Then if I may, Judge, if I could draft another, then I'm going to request that all those fields be suppressed. And if the state agrees with that, then we're in good shape today.
Okay,
so,
hold on.
Out the walk and turn and the one leg stand. If the video's lost or been destroyed, I don't know, but.
So there's a reference to a video, but now there's no video?
So I don't have the file in front of me, Your Honor. I just wanted to address the court regarding counsel indicating discovery because I do have that information before me. Mr. Tipton does have the file in the courtroom, and I'm not sure if there was a reference to a video, the video that he has, or if the other officer even had body cam or video. So what I'm submitting to the court is that we provided counsel with everything.
Okay, I got that part. You've given them everything you have.
Yes, Your
Let
Honor.
me ask, the question I'm asking is there any indication that there exists video other than what you have or what you've provided?
I'm sorry, are you asking me something, Your Honor?
No, I'm asking the state.
Your Honor, I'm reviewing the file now.
Okay.
And what I'm reading here is, I asked Officer L. Jones to run standardized field sobriety test, see Officer Jones' report.
It didn't mention a video.
What does it say? See what now?
See Officer Jones's report, and I don't even have the report, but Officer Hunter was wearing a body cam, so I think it's fair to assume that Officer Jones would have a body cam as well. They're the same agency.
Well, what year was this?
This was a 2000, well, I came on in 2022. This
No,
was
what year was the offense?
2021, Your Honor.
September 23rd, 2021.
Okay, so y'all equivalent about the length of time it took him to file the motions. It's out of time. He's saying that he was expecting to be another video, which has the actual field exercises on the video, and he was not provided with that. You all are saying that you provided him everything you have. However, nobody can tell me whether there was a subsequent video for Officer Jones. Am I correct in my restatement?
That is correct, Your Honor. And the video that we did provide from Officer Hunter did include those fields. He was observing the fields that Officer Jones was performing.
Okay, so what's the problem with going forward with the motion to suppress since Hunter's video has the relevant information?
It's on.
I know the timing, but we do out of time motions.
Well, Your Honor, I believe Mr. Tipton just filed the motion. So the state wouldn't have had time to prepare for the motion. It says
Okay.
similar to other cases that we've had before the court when we have requested to have it dismissed based on counsel filing last minute motions. Not only is it out of time, but it was last minute. So it doesn't give the state enough time to even prepare.
Okay, so we're gonna move the motion to pretrial.
I'm sorry, Your Honor.
We'll move the hearing to pretrial. So when this comes up on a trial calendar and we're ready to try it, we'll have the hearing first.
Okay, and Judge, when's your next trial calendar?
Not sure the next one your case will be on, Ms. Val.
We noticed trials, Judge.
Yeah, it's gonna be a minute. We'll notice you.
You'll notice me?
Yes,
Okay. Thank you, Judge.
you're welcome. All right, Mr. Lynch, tell me your tale of woe about Mr. Harris's case.
Well, I don't have much of a tale of woe, Your Honor. We did file the motion. I have received discovery and some video evidence. My recollection was I thought this was going to be continued to pretrial. That is my preference. However, if that does not please the court, we are ready to go forward.
In the interest of efficiency, this will be continued to pretrial also.
Thank you, Judge.
Your Honor, we do have Officer Stiggers here, so we would object to the continuance.
Wait, is this the one that the gentleman was that we requested everybody to be here in person?
Yes, Your Honor.
Oh, well, no, we're not continuing that. We'll go forward with this one today. All right. Taryn Jarrell Jones, this was a motion to seal. Any objection from the state on the motion to seal?
State would defer to the court, Your Honor.
Notes, if there's no legal reason why it can't be sealed, except it's a battery, but it's a 2019 battery.
And I believe it was null pros, Your Honor.
Oh, yeah, that's right. Okay, then it'll be sealed. Miss Powell, if you'll go ahead and indicate that the court is granting the order. All right.
Yes, ma'am.
Thank you. So now the Jared Alexander Major, that is Miss Hingerty.
Good morning, Your Honor.
All right. So there was a motion to withdraw the plea in order to have a trial. Tell me about that.
Yes, Your Honor.
Still going forward?
If we are able to today, yes, Your Honor, Mr. Major is present. I have subpoenaed Mr. Edie, his trial counsel, to be here. I see him present. So we're ready at the court's pleasure.
All right. Mr. Tipton, whose case is this? Mr. Tipton, Ms. Ponder?
First, Your Honor, the state would ask this court to deny counsel's motion. However, if the court is not inclined to deny counsel motion, the state will ask this court to continue the motion. And the reason for that, Your Honor, counsel filed a motion March 31st, 2025, in which the state was preparing to argue. At that point, I did speak to Attorney Edie as well. I received notice this morning that counsel filed a more lengthy, detailed motion at 4:40 p.m. yesterday.
Okay, so this was on the calendar because Mr. Apt and I talked about it, 2 days ago for the when he came on the Tuesday calendar. So why wasn't that raised at that point? Because otherwise, we got people showing up who Mr. Edie is a working attorney. As if he's showing up as a witness, that means that he's sacrificing money or being somewhere he needs to be. So why wasn't that brought to my attention on Tuesday when we talked about this?
Your Honor, so in the motion that I was preparing for, it indicated that counsel will file a brief in support of her motion based upon after receiving the transcript. Well, this transcript was actually per 11/2025.
It was what now?
May the 11th, 2025. So the transcript was still out there. It's the state's position that counsel, and I could be wrong, may have forgotten about this motion until it was mentioned to Attorney Apt. If the court does recall, he was on a probation hearing and I brought that to the court's attention. I didn't receive a motion, or I would have brought it to the court's attention until yesterday at 4:40 p.m.
All right, Ms. Haggerty.
Yes, Your Honor, that is not true that we forgot about it. I don't understand why she feels that way, but yes, we did receive the transcript. I have been in habeas after court, was able to draft a brief in support to sort of give the state an understanding of what we would be arguing. We spoke with my office spoke with Mr. Edie yesterday. I've spoken with my client, and I did get that motion on file just to sort of give the state a closer idea of what the arguments would be today in the supporting case law. So
yeah, but they are entitled to have notice and the opportunity to prepare. And the fact that you had other cases that kept you from filing and giving them notice. I mean, if you had 2 days notice, you'd be arguing, well, Judge, this isn't fair because I've only had 2 days notice of what the state intends. And I don't have time to prepare. You had enough time to get your witnesses here. You had enough time to figure out what your argument was going to be. And now you want to put the state in the position of arguing something that they've only had a day or less than a full day to prepare for. Now, there's a lot of reasons to ask for a plea to be withdrawn and for someone to have the opportunity to go to trial. Don't have a problem with the the basis of the motion. But I do have a problem with defense attorneys thinking that the court only works one way. And when the defense attorneys cries foul, the court is supposed to jump through hoops. But when the state says, hey, I haven't been given enough notice either, I have to balance the equities between the parties so that all parties receive fairness. And so when you bring a motion that's less than a full day to read through, to appreciate, to gather responses to determine what witnesses you want to bring or what parts of the trial transcript that you might need to highlight, then that's unfair surprise and is trial by ambush. And I don't like that.
Understood, Your Honor, and I didn't object to the state's request to continue the motion.
But y'all are messing up my calendars. So here's the thing. When I leave space, for y'all to bring motions, then I intend that I'm giving you the time from the court. I'm gonna be here anyway, but what I'm saying is there are other motions that I could be hearing instead of, like 2 days ago, I'm like, okay, y'all gonna be here on Thursday. Let's make sure that Mr. Major's here. Let's make sure that the attorney's here. Let's make sure everybody's here on Thursday for this motion. And so I'm making space on my calendar because there are other motions that I could have scheduled and actually heard. But no, I'm dealing with the last minute Lucy's and it's not appropriate.
Your Honor, my first request was to deny their motion, and if the court wasn't inclined to denying their motion, then my second request was for a continuance based on the state just receiving the briefing support at 4:46 p.m. yesterday.
All right. Give me the quick and dirty is the basis for this motion, because I don't know anything other than you want to withdraw a motion where Mr. Major was read his rights, informed of his rights, where I went over it, whether his attorney did or not. I go over it every single time. I can quote you verbatim what I say each time. And he had the opportunity to say yay or nay to want to go forward, you're not going forward. He had an attorney representing him at the time. So tell me why now the court needs to undo what the court has done.
Your Honor, our motion to withdraw his plea is based on ineffective assistance of Mr. Eady. If the court would like to hear from Mr. Eady, that is why we have him here today. But Your Honor,
okay, so if it's based on ineffective assistance, then there's no rush to get that done. We're going to go ahead and continue to the next available motions calendar. I'm not sure when that'll be. Everybody will be noticed.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Yana.
You're welcome. All right, Marquita Dershell Neal, Ricardo Mosby. This is a bond. This was on the bond forfeiture calendar, and this is a motion to recall warrant and remove criminal contempt.
Good morning, Judge. How are you?
But I'm good. I might have a bench warrant, but I don't know that I have a criminal contempt order, unless that's what you're referring to.
I wasn't sure if that was there, just trying to be thorough, so that's why we put that in there. But I will. I was in a case in late March, and we entered our appearance on April 1st. Her appearance for, I think, arraignment, and you guys can correct me if I'm wrong, was March the 6th. And the record shows that they had mail returned on March the 14th and the 17th. Ms. Neal indicates to me that she moved in early 22, actually came in to the court for a traffic ticket and provided a change of address at that point. And so she's actually been in the courthouse, but just needless to say, Judge, on the record, it shows that the mail was returned. And so she does have that proof at her home, and she's been arrested, and we're asking that she be placed back on her bond.
Okay, Ms. Wright, do I have Ms. Wright today? I'm sorry, I'm looking at a pen view.
And the state has no objection, Your Honor, just for the record.
I'm here.
Okay, is there a pending bench warrant?
One moment, I'll look.
And I think, Your Honor, is she currently in custody, Mr. Mosby?
She is. She's in
On my bench warrant?
I believe so. so, Judge.
Okay, because I've asked that question before, and then somebody has verified that, yeah, no, Judge, it's not you. But I'm willing to remove the bench warrant, to set the bench warrant aside. But once she leaves custody, she has to verify. If she said she did it before, I apologize on behalf of the clerk's office, although I don't know how that could have gone wrong. But she needs to verify that they do have the current address, because sometimes people change the address and then they move again. So
Sure.
we go with what we have.
And Your Honor, just to provide the court some information, she is currently in custody on your case, Your Honor, 2022 CR 00622.
Okay.
So I think she's satisfied that bench warrant because she essentially went into custody on it.
Yeah.
Um,
So I just wanted to make sure. I don't want anything else holding her up. So yeah, once she'll be released.
but if I believe
I
we may
need a
have to do bench
no, I need a
warrant.
release order.
Okay.
So
And Judge, what I will do is I'll verify her address, but I'm gonna go ahead.
yeah,
Proper information.
Miss Powell, can we get a release order? Also add to the release order that she's to be released from custody in Stanter, so an arrest warrant release.
Yes, ma'am.
Thank you. All right, and Mr. Mosby, did you have anything else?
I have nothing further, maybe excused, Judge.
Yeah, so Mr. Mosby, so have you spoken to the state about this case? Because I see you filed a waiver, but have y'all had the opportunity to make sure all discovery's been exchanged, make sure that any offers have been communicated?
That, Judge, but it is fairly new. And so we hadn't had a chance to talk. I speak with Mr. Tipton and Ms. Ponder regularly, but
Okay.
like I say, we entered our appearance April 1st and the discovery was, I think, April the 9th. So it hadn't been much time.
All right, I got you.
And Your Honor, we did send discovery, but as counsel has mentioned, it hasn't been time. We sent it on May the 23rd, so right before the holiday, Your Honor. So we did just send discovery to counsel.
All right, so Ms. Challenger is here on Michael Thomas Brasfield. Ms. Challenger, do you have an announcement on Brasfield?
Am I excused, Judge?
Yes, sir. Thank you, Mr. Mosby.
Yes, good morning, Your Honor. Thank you for allowing my tardiness. I was actually in court, in Superior
If
Court.
somebody tells me to hold for a report, I'll hold.
Thank you. I appreciate that, Your Honor. So my client is present. I did see him on the call.
Yes.
That will be a negotiated plea. I've already spoke to the state about that. So we're ready to move forward when the court is ready.
All right, so so far on the calendar, I have Blankumson has a plea, Brasfield is a plea, Gomillion was withdrawn, Greer was reset, Harris and Harris, both cases were moved to pretrial. Jones, that order was granted to seal. Major, that will be continued per the conversation we had. And then Neal is an arrest warrant release and release from custody and stand. Okay.
Your Honor, I believe that the second Harris case, the court was intending.
Oh, no, we're going to hear that today. I'm sorry. You're right, Mr. Tipton. Woo. Yeah, you're right.
Excuse me,
Okay.
Judge.
Yes, ma'am.
Greer is free to leave.
Yes.
Mr. Jones has
good
his
morning.
hand up. I think he's wanting to know if he can leave
Yes,
or.
good
he has
morning,
to
Your Honor.
stay.
Am I
Yes,
able to? Am I
Yes,
able
Mr. Jones,
to?
you're able to leave. Thank you. So for all of you, these are the only cases that we're going to still need people to stay. Blankumson, Brasfield, and Harris. We're good. Everybody else who is here for a hearing is excused at this time.
To
All
confirm,
right.
to confirm, Latoya Ware is free to go
Ms. Ware, you were here on which case?
for Jemiah Greer.
Yes, ma'am. You're free to go. And the professionals at Victim Witness Assistance Office from the solicitor's office will contact you. Okay.
Okay, now I want to make sure they have an updated number 678.
Okay. Wait. So we're live streaming, so you don't want to just put your number out there. Can you chat it?
Judge, I already have her number.
Okay, Investigator Robinson has it. Yeah.
Okay, then. Thank you.
All right. Take care.
Okay, you too now. Bye.
Okay. So, are we ready on Blankumsen?
Yes, Your Honor.
Come on up, sir. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, I do, Your Honor.
All right, you can put your hand down. Mr. Solomon Blankumsi, 2024 CR 09350. You're represented by Attorney Corey Washington. He's with you at the podium. Mr. Washington, your client is charged with the offenses of driving under the influence, count 1, open container, count 2, open container, count 3, and improper lane change, count 4. What does your client plead to the offenses before the court?
At this time, not guilty.
Your Honor, we have reduced count 1 to a reckless driving.
Okay, so count 1 will be per the amended accusation, reckless. Count 2, open container. Count 3, open container. Is one of those an ordinance violation or both state?
One of those is an ordinance violation, Your Honor, but the state's null crossing counts 2 through 4. So we're only
Okay.
on the amended count 1.
All right. So per the state's amendment to case 2024 CR 09350, Mr. Blankumsi will be pleading to reckless driving. And Mr. Washington, what is he pleading to that offense?
Guilty to.
All right. All right, by entering a plea of guilty, sir, to count 1, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, Your Honor.
All right, factual basis and recommendation, please.
Yes, Your Honor. On September 18th of 2023, officers with the Clayton County Sheriff's Department were involved in a road safety check where the defendant before you, Mr. Blankumsi, approached. Upon approaching, they observed an open container in Mr. Blankumsi's car. They then went through several field sobriety. They then asked if he would participate in field sobriety tests, but he refused. They asked him for a chemical test of his blood, which he refused. The nature of the Less Safe Act was such that the state does not believe it can go forward on a DUI less safe, but that a reckless driving would be appropriate. The state wished to place that on the record since Mr. Blankumsi is a CDL and the state wanted to avoid any type of masking.
Yes.
The recommendation, Your Honor, is 12 months probation, a DUI risk reduction course, no drugs or alcohol, subject to random testing, substance abuse evaluation, and any recommended treatment, 40 hours of community service, and a $300 fine.
Okay, I'll say that for somebody who is actually a little slower than you.
My apologies, Your Honor. I'll go forward. I'll go back on that. It's going to be 12 months probation, a DUI risk reduction course, no drugs or alcohol, subject to random testing, substance abuse evaluation, and any recommended treatment, 40 hours of community service, and a $300 fine.
All right. All right. So, Mr. Washington, anything on behalf of Mr. Blankumsi?
No, Your Honor, we just asked the court if they accept this plea recommendation, and also with his probation, possibly termination or not reporting after he completes those conditions.
What's the state saying?
Your Honor, if he wants to petition the court after after completing everything, at that point, I think that would be appropriate to bring up, but not prior to that point.
Yep, that's what I feel about that. Mr. Blankumsey, I'm going to accept your plea of guilty to the amended charge of reckless driving. Counts 2, 3, and 4 will be no pros per the agreement between your attorney and the state. I'll send you on that count to 12 months probation, a DUI risk reduction course, no alcohol or illicit drugs during the course of your probation, and you are subject to random screens for alcohol and drugs, a substance abuse evaluation, and any treatment that may be ordered after that evaluation, 40 hours of community service, a $300 fine. Sir, just be mindful that being on the road is an awesome responsibility, and we sometimes take that for granted. You don't want to wake up every day knowing that you've caused harm to yourself, your family, or someone else. So please be mindful that when you're on the road, it is important to drive safely, and if not, seek other means of travel. You understand?
Yes, Your Honor.
All right, so when you leave the courtroom, you're going to go out to your right to the courtroom 305. The probation expert, Ms. James, is going to be in one of those first offices when you go through this first set of double doors into that courtroom. If she's with someone, she'll ask you to wait until the hall until she can do your intake. Please ask her any questions that you have regarding your situation, whether it's your work situation, travel situation, where you live, anything that might make it difficult for you to successfully complete probation. Please clear that up with her. And also understand that the quickest way to get rearrested is to not report for probation. You have to report. If you're having difficulty with anything, your probation officers are here to make sure that you successfully complete probation, but you got to work with them. Okay. All right. Thank you. Just exit the courtroom. Please do not leave the building before you speak with probation.
Oh.
All right.
Oh.
Thank you, Mr. Washington. You're free to go at this.
Thank you, Your Honor.
All right. All right, Ms. Challenger, we ready?
Yes, Your Honor, we're ready.
Thank you. Mr. Brassfield, may I see you, please? I'm gonna send you a prompt, so that might help.
And Your Honor, so the court's aware the state's only going forward on the window tint violation and the speeding.
Okay. Mr. There you are. All right. So, 1 second, sir. So, Mr. Michael Thomas Brassfield, case 2024 CR 10303. You're represented by attorney Sharice Challenger. You're charged with count 1, aggressive driving, count 2, reckless driving, count 3, following too closely, count 4, no signal, improper turn, count 5, erratic lane change, count 6, window tint violation, count 7, too fast for conditions, and count 8, speeding. And Mr. Tipton, you said you're only going forward on the number 6 tint violation?
The tint violation, Your Honor, and number 8 speeding violations.
Okay. All right. So, Mr. Brassfield, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true? I can't hear you, sir. Speak up for me.
Yes, Your Honor.
All right. You can put your hand down. All right. So, Ms. Challenger, what is your client plea to count 6 and count 8?
Your Honor, those will be guilty, please.
All right, by entering a plea of guilty to count 6 and count 8, counts 1 through 5 and count 7 will be no pros. You give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, Your Honor.
All right, fact basis recommendation.
Yes, Your Honor. On October 15th of 2023, officers with the Clayton County Sheriff's Department, while on routine patrol, and while using a laser that was properly calibrated, did observe the defendant before you, Mr. Michael Thomas Brassfield, traveling on a stretch of I-75 that is within Clayton County at a rate of 118 miles per hour, where the posted speed limit was 65 miles per hour. Mr. Brassfield was then pulled over, and it was determined that his windows were tinted darker than is legal in the state of Georgia. The state's recommendation, Your Honor, is a $100 fine for the window tint violation and a $1,000 fine for the speeding. Mr. Brassfield has already completed a defensive driving course, which Ms. Challenger has provided to me. He otherwise has a very good driving record, which is why the state was willing to dismiss the other counts.
All right. Ms. Challenger, will your client need additional time? I usually give everybody 30 days if they're not at the courthouse. Will he need up to 60 days to pay the fines and fees, or will he need a probation pay only option?
Your Honor, we did talk about probation and then to terminate upon the completion of probation. But Mr. Brassfield, are you able to pay that within the 90 days?
Let me make sure that I can that he knows the total. So the $100 fine with the surcharges is going to be $151.50. That'll be that total. The $1,000 fine with the surcharges is going to be $1,420. So now that you know the numbers, what option will you need? I can give you 12 months pay only probation, and you're required to pay and show up, but your probation ends as soon as you've paid all of your fines and fees. And I'll run these concurrent so you can pay them all during the same period of time. Or you can have up to 60 days to pay without being put on probation, but you need to pay by this on or before the 60th day in that case.
60 days.
All right, so Mr. Brassfield, make sure that you are diligent in making these payments. What I'm going to ask you to do you know how to use the chat function? No.
No, not really.
Okay, so look on your screen. You should see a red box with a white number in it.
Red box, white number.
If not, activate the screen next to your name. Do you see a blue box with 3 white dots?
No, but I got a little chat up here on my
Yes, that's what you're looking for.
right.
So click on that.
Okay.
Do you see a name in blue?
So it
Should say.
I can see whether everybody who's
That's
on the
what
chat.
I'm talking about. Click on the blue everyone.
Okay.
All right, you should see a menu come down. The first name on that menu should be Amanda Wright, R-Y-T-E. Do you see it?
Yes, ma'am.
Okay, click on that.
Okay.
A box should open. All right, I want you to put your email address into that field. Please make sure you check and make sure the numbers and letters are in the right order. Okay, so Ms. Wright is going to send you your sentencing sheet. So please make sure you check. If it's not there, check your spam folder in the next day or so. It'll tell you when the exact date by which you need to pay. You can come into the Clayton County Justice Center at 9151 Terra Boulevard in Jonesboro to pay in person on the second floor at the traffic court window. Or you can pay online or by phone, but you need to listen to the instructions or read the instructions carefully for how to pay online or by phone, okay?
Yes,
Yeah. The chat with his email address did not come through.
Did you hit send, Mr. Brassfield?
Okay, I got it.
You got it?
Yes, ma'am.
All right, good. All right, so Mr. Brassfield, at this time, you're excused. Please make sure you look for your sentencing sheet in the next couple of days, but if, like I said, if you don't find it, make sure you check your spam folder, okay?
Yes, yeah.
All right, and you do not want to miss that deadline to pay, because you do want to complete the suspended sentence.
Yes, yeah.
All right, Ms. Challenger, thank you so much. It's been a pleasure.
Likewise, Your Honor. And Ms. Wright, I'm sending you my email address as well, if you want to copy me on it too, just in case there's any issues with Mr. Brassfield. So I'll make sure that he gets it, okay?
Yes, ma'am. Thank you.
Thank you. Thank you, Your Honor. Good to see you as well.
All right, thank you. All right, I'm ready on Harris.
Your Honor, I'm sorry, your audio skipped a moment.
I am here. Can you hear me?
Yes.
Okay, I'm here.
So, Mr. Lynch,
Yes, Your Honor.
come talk to me for a minute.
Yes, and by that, do you mean from this?
Yeah, no, so you insisted that everybody be in court and then Mr. Harris is at his house?
Yes, Judge. My understanding that this was continued to pretrial and
Where did you get that understanding?
that's what I thought happened at the last motion calendar, Judge. Mr. Harris is in Colorado. I wanted to be able to confront the witnesses in person in court. My preference was to have him present pretrial.
Okay, that might have been your preference, but that's not the discussion that we had. Does anybody else remember pretrial? Because I do not.
No, Your Honor. Typically, what I've noticed from the court is that if it's pretrial, it's because there is a request for a continued statement requested a dismissal or a motion to deny. But it's not typical for the court to have it pretrial unless it's one stated in the rule nasi, or is if we requested to have that motion dismissed and then you put it pretrial. But I don't recall that taking place because that would have put his other case where Attorney Ward was on pretrial, and that was not the discussion to my understanding.
So,
Yeah, I don't recall us saying that this case was going to be pretrial. So what's the issue?
well, Judge, my recollection to pretrial, Mr. Harris is here present. We are prepared to go forward. I know that I did indicate that I wanted the officer to be present, and that's why my understanding was that it was going to be moved to pretrial. But
And I was
we are willing to go forward. We're certainly ready to go forward. Mr. Harris is present via Zoom. My wanting to have
well, the gentleman in question, the witness in question, as my understanding, was coming off of a medical leave due to an on-the-job injury. So I thought we were trying to accommodate that, but you insisted that he be present, and the state got him present. So what's the issue?
And I'm not asking. I did ask that it be moved to pretrial, but Your Honor denied that, and we are prepared to go forward. And
okay.
My preference, the reason I wanted it to be done pretrial is because I wanted to be able to question the officer from the witness stand with Your Honor present in the courtroom, be able to view that, in this situation, it's easier for me to do this on Zoom. So I'm not standing next to the officer while questioning him, Judge, but I'm not jumping up and down about that and making objections, Judge. I'm ready to go forward in this situation, but,
And Your Honor, I would just like to add to that point. I did have an opportunity to ask Ms. Arnold to look at the notes that was placed on the calendar last time it was on the court. This case was scheduled. There was no date set, is my understanding, but it was continued so that witnesses could be present. And so essentially that's what took place. When it's pretrial.
May I just make a point, Judge?
Wait,
I'm sorry,
not, My understanding was this officer was out on an extended medical leave. And so you insisted that he be present, and I said, fine, we'll continue it until the officer can be present. They
Yes,
made the officer present.
yes, and Mr. Harris is present via Zoom, and he can waive his presence to this hearing.
That's not fair.
Mr.
You request, Your Honor, the defense requested for witnesses to be in person.
Yes, Mr. Harris.
For Mr. Harris to be on his house while an officer is in court, the attorney is in court, the state is even in court because it's Mr. Tipton's motion. He is even in court. Everybody is in court in person except Mr. Harris. And they've requested us to have witnesses present in person.
Yes, and that is our right to request witnesses to be present in person. And Mr. Harris can waive his presence at this hearing. He is not a witness that's going to testify at this hearing. It's also unfair for Ms. Ponder and Mr. Tipton to double team me in this manner about this issue. I am I'm here ready to go forward on the motion. The officer is present. I'm not sure what the issue is. Mr. Harris can
All
waive.
right. So, okay, I've heard enough. We're going forward. So this is the state of Georgia versus Donnie Harris. Mr. Harris has two cases pending, but this is the particular case of case 2022 CR 01475. Mr. Harris is represented by the law firm of Lister, Holt, and Dennis. Mr. Lynch, Owen Lynch is present and representing Mr. Harris. Mr. Harris is not present in court, but he is present by Zoom, present by video. My understanding is from Mr. Lynch that he is not likely to testify in this matter.
Sector 4 Watch Office.
All right, whoever is speaking needs to mute. Mr. Harris is charged with DUI less safe, driving under the influence, count 2, and traffic violation count 3. All right, are we ready to go forward on the motion to suppress?
We are, Judge. Before we go forward, I just wanted to mention to the court that we do have a stipulation in this case that the Officer Stigger's body cam video is admissible for the purposes of this hearing to state.
That's fine. Body cam will be admitted into the record for this hearing as stipulated.
Thank you, Your Honor. Your Honor, this is would like to call Officer Janelle Stiggers.
All right. So, Mr. Tipton, because of the limitations of the court reporter being on video, you have to make sure you direct your voice towards the camera. All right. Raise your right hand for me, sir. Do you solemnly swear or affirm any testimony you give in this matter will be true?
I do.
All right. Mr. Tipton, your witness.
Thank you, Your Honor.
Excuse.
Officer, please state your name for the record.
I'm Sergeant Jamel Stager.
And Sergeant Stiggers, how are you currently employed?
I'm currently employed with the Clayton County Sheriff's Office.
And prior to Clayton County, where were you employed?
I was employed with the Jonesboro Police Department.
How long were you with Jonesboro PD?
I was with Jonesboro Police Department approximately 4.5 years.
Okay. Did that include May of 2021?
I did.
Okay, thank you. Are you post-certified?
I am.
Being post-certified, are you authorized to investigate crimes, issue citations, and make arrests?
That's correct.
Okay. So did you have to complete mandated training to become post-certified?
That's correct.
Okay, when did that happen?
2019, December 2019.
Are you required to complete a certain number of hours of training per year to keep up your post-certification?
I am.
Okay. Have you done this?
I have.
Have you always been post-certified since getting that initial post-certification in 2019?
Yes.
Okay. Are you trained in the detection of persons under the influence?
I am.
Can you briefly go over the training you've had?
While in mandate, we took the DUI course, which is I'm not sure how many hours it was, but there's a course that was added into my training to allow us to detect a person under the influence of alcohol or drugs while operating on a vehicle.
Okay. So I want to draw your attention to DUI arrests. Approximately how many have you made? Just give me a ballpark if you got it.
30 plus.
30 plus, okay. And did you use your training to effect these arrests?
Yes.
Okay. So I want to draw your attention to May 4th of 2021. Were you employed with Jonesboro PD at this time?
Yes.
Okay, and were you post-certified on this date?
Yes.
Were you on duty in uniform and in a marked patrol car?
Yes.
Okay, what were your duties that day, generally speaking?
I duties at that time, general patrol of the city, within the city limits of the city of Jonesboro.
Do you recall making contact with defendant Mr. Donnie Harris?
I do.
Okay. Can you tell me about first contact? About what time of the day was it?
It would have been nighttime.
Okay. And what were the weather conditions like?
It was raining and wet outside. I had my rain gear on.
Okay. So tell me about that initial contact. What was that initial contact like?
Initial contact with Mr. Harris was, he seemed to be agitated.
Okay. So why did you make contact with Mr. Harris? What did you observe as far as driving?
Mr. Harris had see through a fully established red light, but operating his vehicle by running a red light.
And did that cause you to be concerned about his driving?
It did.
Why is that?
Because due to the weather conditions outside and the other people on the roadway, him running the red light posed a danger to the other citizens on the road.
Okay. So is that what caused you to make the traffic stop?
Yes.
Okay. When you first saw him and you mentioned he was agitated, did you notice anything about did you notice anything about his person?
When I first saw him, I noticed his eyes were glassy, but it's not necessarily a prime indicator. A lot of times with his being older in age.
Okay. So when you initially made contact, what did you do after that?
I went back to my car with his information and ran it.
Mm-hmm. And when you returned with the citation, what happened at that point?
When I returned the citation, due to the rain coming down and the citation being made of paper, I leaned into his vehicle a little bit more to explain the citation and to get him to sign it. And I was able to notice the odor alcohol coming from this person.
Okay. Did you ask the defendant if he'd been drinking that day?
I did.
What did he say?
He told me it was the day before.
Based on your investigation, did you investigate further? Based on what you saw so far, did you investigate further?
I did.
Okay, what was the next step in your evaluation?
My next step, due to the fact that we were in the construction zone and it was raining and we were on the side of the road, I asked him if he would be willing to provide a small sample of breath test, portable breath test.
How did he respond?
He told me he wouldn't give me that breath test, but he would give me blood.
Okay. Okay. And based on that, what did you do, sir?
I called for another unit. I'm still by. I called for another unit. When another unit arrived, he was taken in custody and advised that he was in custody for his operation, as well as being under the influence. And he asked me if he was going to go get blood. I told him when we get down to the jail, blood will be taken.
At that point, did you read him anything?
I did read him implied consent.
Okay, what color card did you read?
A green one.
Okay. Okay, I'm going to show you a recreation of an implied consent card. Is this the same card that you read?
Yes.
Okay, Your Honor, I'm going to be sending the court a copy of the implied consent card. It's just going to be this exact scan. It'll be sent by email. States admin.
You can send it to Ms. Martin, but that's fine. Yes.
Thank you. Can you please tell me which portion of the card you read?
I read the portion that states implied consent notice for suspects age 21 or older.
Okay. Can you read to the court the portion of the card that you read?
I read implied consent notice for suspect age 21 or over. State of Georgia has condition and privilege to drive upon the highways of this state. Upon your submission to the state administered chemical test of your blood, breath, urine, or other bodily substance for the purpose to determine if you are under the influence of alcohol or drugs. If you refuse this state testing, Your Georgia driver license or privilege to drive on the highways of this state will be suspended for a minimum period of 1 year. Your refusal to submit to blood or urine testing may be offered in the evidence against you at trial. If you submit the testing and the results indicate an alcohol concentration of 0.08 grams or more, your Georgia driver license or privilege to drive on the highways of this state may.
You're almost done. Click open file in the top right to continue.
Mr. Harris, I keep muting you because your sound is bleeding in. So just leave your device muted unless you need to speak, okay? Thank you. Go ahead.
At the first amendment, the requested state test, you are entitled to additional chemical tests of your blood, breath, or urine, or other bodily substance at your own expense from a qualified professional of your choosing. Will you submit to the state administered chemical test and offset blood?
I got you. And how did he respond to the test, to you asking for a test of his blood?
He'd already agreed, but he said fine.
Okay. And how was your tone of voice when you spoke to Mr. Harris?
Moderate, just speaking to him.
Did you do anything did you act in a way that would have been threatening to?
No.
Okay. Okay. Your Honor, at this point, I'm going to be playing the body cam footage of Mr. from Sergeant Stiggers. It'll be played. I'm sharing my screen off of my computer.
Okay.
Yes. Okay. And Your Honor, I've got some timestamps, just don't want to be going all over the place.
That's fine.
Your Honor, state is starting, the video will be starting at 0 minutes and 0 seconds, and we'll be stopping at 1 minute in.
Okay. Am I supposed to hear it too, Mr. Tipton?
Yes, Your Honor. Yes, Your Honor. Is there an issue with the hearing?
I'm not hearing anything. Is anybody hearing any of the ambient noise from the video?
Wait for a second, the volume just cut off.
Looks like it's only coming from my computer, Your Honor. 1 moment.
How you doing today, sir? My name's Officer Jonesville Police Department. The reason I stopped you because you ran the red light. You have a driver's license with you today?
Talking online with my fiance.
Judge, can you hear it now?
Yes.
Thank you.
All right. Give me 1 moment. I'll be right with you, okay?
State is stopping at 1 minute. That was the initial contact. Resuming at 5 minutes and 4 seconds, and we'll play until roughly 12 minutes and 20 seconds.
All right, sir. You been issued a citation for beating the traffic control device. You have a court.
Listen, can you
You have a
just
court
give me
date set
one?
for the 28th of June
Oh my God, man,
at 2
can you
p.m. at
please just
170
give me a
South Main
warning?
Street. If you choose to take care of your citation ahead of time, you can utilize the phone number on the website on the back side of your copy. You can just sign here and sign my admission, get this thing, give me a copy of the citation, okay? What's that, sir?
I'm not gonna sign it.
You're not gonna sign it? Let me ask you a question. I can detect the odor of alcohol coming from your breath. When was the last time you had a drink?
Shit, I don't know. Yesterday.
Yesterday?
Yeah.
Okay, why does it still smell like you have the odor of alcohol coming from your breath
No,
today?
I didn't have no alcohol, man. Listen to me. I was on the phone with my fiance who was on in Philippines, and she had just freaking called me, man.
1615. You start me at 74 and rep to 30.
Please, sir. Please, I worked in law enforcement for 23 years. Can you just give me a fucking... I just
All right,
moved
sit
here
tight
from
for me, okay?
Colorado.
Sit tight for me, okay? Hey, give me 1 moment, all right?
Can you just give me a warning, man? I worked in law enforcement for 23 years. For 23 years, man, I was on the phone. She just called me, man. I answered the phone. I went through the fucking the light.
Okay.
Lord have mercy, man. Can you please? I'm begging you, please. Just give me a warning, please, sir.
Unfortunately, I already printed a citation, so can't give you a warning on that, but I have to figure out what's going on with this smell of alcohol coming from you, bro. So give me a moment,
I
okay?
have no alcohol, man.
You haven't had any alcohol? Alright, well, I know due to the weather conditions out here right now, will you be willing to provide a small sample of your breath to a portable breath in this, whether or not you had a present alcohol in your breath or not?
Man, my fiance's in it. God, Lord have mercy. I cannot win for losing in the state,
I'm just asking you a question. Are you willing to do so?
Do what?
I said, are you willing to provide a small breath sample of your breath to determine whether or not you had the presence of alcohol in your breath or not?
I'll do a blood.
A blood?
Blood, yeah. I do a blood.
So you willing to give blood, but you're not willing to give a small breath sample?
I do a blood analyzer, man.
Like I said, well, we don't have to go as far as blood if you can provide a small breath sample.
I do a blood analyzer.
You do a blood? Okay.
Man, please give me a blood.
I was wondering why you didn't pull over in the gas station and kind of.
Well, hell, you just.
Well, we had blue lights on for a minute. I didn't know. They were on for a minute.
I'm trying to find a safe place.
You could have pulled us to the gas station. You gonna pull into the gas station?
You just hit me, man.
Who?
You.
I hit you with what? Huh? With the blue lights? I turned the lights on. They didn't hit you. They just on.
You didn't give me the citation.
Huh?
Give me the citation.
Well, like I said, I'm asking you the simple part. Are you willing to provide a breath sample? You told me you want to get blood, so.
I do blood.
Huh?
I do blood.
You only do blood? All right, like I said, due to weather conditions and. All right, give me a moment, okay?
Man, I just moved here from Colorado. This is the freaking third ticket I've had, and I'm not even fucking at fault here, man.
Mm-hmm.
I mean, I did go through the ticket, go through the light, and I realized that at the fucking. My lady called me.
I understand.
Man, no, you don't. No, you don't. You're not.
Okay, I tried to give him a ticket, but then I had to lean in and keep him wet. I said, all right. He started arguing with me, and he started yelling. I'm like, oh, okay. So I said, sir, I can detect all the alcohol coming from your breath. I said, have you had any alcohol? He said, yesterday. I said, okay. I said, well, due to the weather conditions right now, I said, you willing to provide a portable breath sample to determine whether or not you have any on your breath or not. He said, I get blood. All right. Sir, let me get you on to step out for me, okay?
What?
Get you to step out the car for me. What's with the peppermint?
All right.
You got any weapons or anything on you? Okay, well, you're gonna be placed in custody today for operating a motor vehicle in an unsafe manner, okay?
Unsafe manner?
Sir, don't resist, okay? Yeah, the less safe act that I observed was you running that red light, and then due to the fact that I can detect all the alcohol coming from your breath, Like I said, I asked you if you're willing to provide a breath sample. You told me you give blood, so we're gonna go ahead. That's fine. When you get that jail, since you agreed to go get blood, you can get blood at the jail, okay? We'll get that taken care of in a second, okay? Let me get you step over here out of the way of the public, out of the way to the. I'm gonna pat you down, make sure you don't have any weapons or anything on you, okay? Is this your glasses? Yeah. What's this? iPods? Alright, then come this way for me.
Well, don't drag me, man.
I'm not dragging you. You're kind of stumbling a little bit on me.
No, I'm not. You're dragging me, man.
Well, on the move fast, and you moving, rocking back and forth for some reason.
No,
Sure.
I'm not moving back and forth, man.
Okay, well, go on and get a step in for me, okay?
Can you please, like, roll up the windows of my
We're gonna take
vehicle?
that in a second. Once I get to all that, once I get you in the car and secured in the car. I'll take that off for you. Gonna dip your head in there for
Can
me.
you slide this seat up a little bit?
Ain't no sliding the seat up. It's a cage. It don't move. So you gotta slide. You gotta slide yourself in there. There you go. Go and get the other foot in there for me. That's good enough. Oh, make sure you get your foot in there.
Wait a minute.
There you go. Should be enough. There you go.
State is pausing the video at 12 minutes and 23 seconds. State will restart the video at 13 minutes and 13 seconds.
All right, sir, I got to read this to you even though you agreed already, but I have to still read it, okay?
Man, these cuffs are hurting my hand.
I understand. Give me a moment.
Can I get
This
out?
is apply consent notice for age 21 years or older. The state of Georgia has conditioned your privilege to drive upon the highways of this state upon the submission to the state administered chemical test of your blood, breath, urine, or other bodily substance for the purpose of determining if you're under the influence of alcohol or drugs. If you refuse this testing, your Georgia driver license for the drive on the highways of this state will be suspended for a minimum period of 1 year. Your refusal to submit to blood or urine testing may be often in evidence against you at your trial. If you submit to the testing and the results indicate an alcohol concentration of 0.08 grams or more, your Georgia driver license or privilege to drive on the highways of this state may be suspended for a minimum period of 1 year. After first submitting to the requested state test, you're entitled to an additional chemical test of your blood, breath, urine, or other bodily substance at your own expense and from a qualified professional of your choosing. Will you submit to state administered chemical test of your blood?
Yes.
Okay. Thank you, sir.
State is stopping the video at 14 minutes and 24 seconds. So Officer Stiggers, after reviewing that video, how would you describe the defendant's demeanor?
And he was in an agitated state associated with the possibility of being under influence at the time. He was slurred speaking. I don't know what he was stating about the time.
Okay. You didn't initially detect the odor of alcohol. Why were you able to determine it later?
I got closer and got inside the vehicle a little bit closer. Initially, when I got to the car, I didn't even get close to the window. With traffic, due to traffic, I was standing at the point where I could see traffic come from behind me.
And did this all occur in Jonesboro?
It did.
And is that complete? And was that within Clayton County?
Yes, sir.
All right. Thank you. I have no further questions at this time.
Cross-examination, Mr. Lynch?
Yes, one moment, Your Honor. I want to go back to the no, it's on your last one. Can you help me with that?
Yes.
Okay. Excuse me, this is a little bit different. So Officer Stiggers, you testified about DUI detection training that you had undergone prior to making that arrest. Is this correct?
That's correct.
And I don't want to be inaccurate, but I believe that you indicated that the training that you received was in the academy?
Yes, it was another class attached just to get it out of the way while we were in the academy.
Okay. And as part of that, as part of that training, were you trained in standardized field sobriety testing?
I was.
Is it accurate to say that field sobriety testing is an tool in your tool belt to determine if someone is a less safe driver if you have that suspicion?
It's a portion of the tool belt.
Okay. Now, I want to move back to the initial contact that you had with Mr. Harris. So you initially pulled him over because you testified you observed a red light violation. Is that correct?
That's correct.
And you turned on your blue lights, right?
That's correct.
And Mr. Harris pulled over to the side of the road. Is that correct?
Yes.
While he was pulling over to the side of the road, observe any additional traffic violations, did you?
I didn't note any additional.
You did not note any additional traffic violations. And when you approached Mr. Harris and asked him for his driver's license, he produced that to you promptly. Isn't that correct?
I would say you did.
Okay. And at that point, you returned to your car and issued him a citation for running a red light. Is that correct?
Yes.
And when you returned to the car, you presented him with the citation and told him that you were going to be citing him for running a red light, right?
That's correct.
Okay. And at that point, he initially indicated that he didn't want to sign the citation. Is that correct?
Yes.
Okay. And immediately after he said that he wasn't going to sign the citation, your statement to him was, "You're not going to sign it. Okay. I smell the odor of alcohol on you. How much have you been drinking?" Isn't that correct?
I don't think that's in that meeting.
I believe your exact statement is, "What's that, sir? You're not going to sign it? Let me ask you something, sir. I can smell the odor of alcohol on you. When was the last time you had a drink?" Isn't that correct?
I said that one, yes.
Correct. And that's that statement was made immediately after he indicated that he was not going to sign the citation, correct?
Yes.
Okay. And you mentioned at this point that it was raining outside, right?
Yeah.
Was it raining at the time? Okay. Now, when you pulled over Mr. Harris, you indicated that, he could have pulled over into the Quick Trip gas station right there on Terra Boulevard. Isn't that right?
That's correct.
And you're familiar with that Quick Trip, right?
Yes.
Probably go there often since it's right next to the Clayton County.
Not necessarily.
Okay. We'll come back to that. So immediately after that, you indicated to Mr. Harris that because you smelled the odor of alcohol, that you were going to have to do a further investigation as to why you smelled alcohol on his breath. Is that correct?
That's correct.
Okay. And you told him that due to the weather conditions, would you be willing to take a portable breath sample?
That's correct.
And he told you that he would do a blood test, but he didn't want to take a portable breath sample, right?
That's correct.
Okay. And at that point, you talked to another officer who had arrived on the situation to him, right?
Yes.
Okay. And after talking to that other officer, you instructed Mr. Harris to exit his vehicle, correct?
That's correct.
And at that time, or shortly thereafter, in a matter of seconds, you placed Mr. Harris under arrest, correct?
That's correct.
Okay. So you mentioned that you were trained in standardized field sobriety testing.
That's correct.
In this case, so you've been trained on how to conduct horizontal gaze nystagmus, is that correct?
I was.
And that's an important test because out of those 3 standardized field sobriety tests, it's the only scientific test that provides an objective indication of alcohol level and perhaps impairment. Is that correct?
And it doesn't suggest alcohol level.
Okay, fair enough. but it is an important tool in your tool belt to be able to determine whether someone may have alcohol in their system.
They may be impaired under something.
Okay, okay. Could be as some other CNS depressant, right?
That's correct.
Okay. You chose not to conduct the horizontal gaze nystagmus test in this arrest, isn't that correct?
That's correct.
Okay. You chose not to conduct the divided attention test, namely the walk and turn and the one leg stand, isn't that correct?
That's correct.
Okay. And your reasoning for that is because it's raining, isn't that correct?
That was not my reason.
Okay, what was your reason?
My reasoning was the totality of the situation and location where we were.
Okay. So you instructed Mr. Harris, well, other than Mr. Harris running the red light and your claim that you smelled alcohol on his breath, you did not develop any further, or you did not do any further investigation into whether Mr. Harris was in fact impaired.
I did.
And what was that investigation?
He agreed to give me blood, so the next step would have been to take blood, and once we got blood, to indicate whether he had alcohol.
A blood test is a state chemical test, is that correct? And a state chemical test is not administered in an arrest, isn't that correct?
Not necessarily.
In this case, he was arrested, and then you read him implied consent, isn't that correct?
Yes.
Okay.
No, he agreed to blood, then he was arrested.
Okay. Do you think his agreement to give a blood sample is evidence that he was impaired?
Now the smell is the evidence.
Okay. And I believe you wrote a report in this case, isn't that correct?
Yes, sir.
And in your report, and if you need to refresh your recollection, I can show you your report. You did not indicate that when you first made contact with Mr. Harris that his eyes were glossy, did you?
I did not.
Okay. You also indicated in your report that his refusal to give you a portable breath sample was one of the reasons why you arrested him. Isn't that correct?
No, I told him I was listening as one of the totalities of why I made the decision to detain him arrested.
Okay. Okay. Now, is there something in your training that says you cannot conduct standardized field sobriety tests while it's raining?
Yes, during the training, it was officer's discretion to use reason and the location and the surroundings of where you were to not do certain things that would either put the other public in safety in question or put that person in jeopardy of being in an unsafe place.
Okay, so you could have used your discretion to move the investigation into the Quick Trip parking lot where there was a roof where you could safely conduct these tests in a dry environment, but you chose not to do that.
No,
Is
sir.
that correct?
I wouldn't make that move.
Why not?
Because I would have to leave his car there, and if I would have determined that his car got hit or something due to that not having blue lights behind it. So
Well, you could have put him in the back of your car and transported him.
Objection, Your Honor. The defense counsel's testifying at this point.
Sustained.
Couldn't you have transported him to the Quick Trip parking lot and done standardized field sobriety tests there?
not necessarily.
What do you mean by not necessarily?
The Quick Trip parking lot was on the opposite side of the road, and the only way to get to that road now and turn around and come back to the scene would have been pointless.
Why would it have been pointless?
Because the next parking lot would have been further up, would have been more feasible than going backwards.
So you had two parking lots you could have chose to go to.
Yeah, that's correct, but the spending could also put it into a parking lot.
Okay. Just to go back, you did ask him if you had anything to drink in this investigation, right?
That's correct.
And he told you that he hadn't had anything to drink.
That's correct.
You know, I'm gonna have this one moment.
You may.
when you initially were presenting him with the citation, you did not suspect that he was an impaired driver at that time, isn't that right?
I'm not sure on the question.
When did you first suspect that Mr. Harris was an impaired driver?
After I leaned in to give him a sign ticket, he started speaking. I could smell the odor coming from his breath.
Okay. And so you smelled the odor of an alcoholic beverage, and that triggered a suspicion that he may be impaired.
Yes.
And from that time until he was placed under arrest, you did not do any field sobriety tests, correct?
Yeah, do the location and
no questions.
Your Honor, may the state redirect?
Yeah.
Oh, thank you, Your Honor. So Officer Stiggers, walk me through an ideal place to do standardized field sobriety tests.
an ideal place will be a place, location where the subject will be in a place where he'd be away from traffic, at least block the area where he can't get on directly away from traffic with other patrol cars. But where we were at that time of day was on a hill in a construction zone. It would have been raining outside in the time of day. With it dark, it would have been it wasn't ideal to conduct anything out there.
As an officer, how important is safety to you?
Very safe.
Okay. Whose safety were you concerned with during the stop?
I'm concerned with everybody's safety, mine's, the offenders, the general public at large that are passing by, anybody driving by the road.
Mm-hmm. And at the time, you were able to, you made the determination that it was unsafe, correct?
That's correct.
Walk me through all the unsafe things you saw.
Standing water on the ground, the orange construction cones to the right of my vehicle that we were in. Another part is that we have to remove our blue lights from the front of our vehicle in order to conduct HGN. And due to the fact that it's dark outside, that takes the availability 500 feet away. Some of the 500 feet away from the vehicle's ability to be seen at 500 feet when we have to turn certain lights off.
Why do you turn those lights off?
Because it's been known that the lights affect the outcome of the person being tested for HGN.
How heavy was traffic?
It was light.
But were cars passing?
Yes.
Did those cars have their lights on?
They did.
Based on your knowledge, training, and experience, could those lights affect HGN?
They can.
Okay. Now the other tests are walk and turn. And I'm sorry, what are the other two tests?
One is walk and turn, and the other one is the one leg stand.
You mentioned standing water. How would standing water have affected those tests?
He could have slipped and fell.
Could that have potentially injured him?
That's correct.
I also want to ask, what were your safety concerns? Do any of these tests require the defendant to move his body?
They all, two of them do the walk and turn, and the one leg stand, not necessarily, but we have to place them in a safe area.
Fast with cars.
The speed limit on that roadway is 45, and entering the construction zone is supposed to go down to 35, but it's not necessarily known that they will slow down.
Based on your knowledge, training, and experience, could someone get injured if they were hit by a vehicle that was traveling 35 miles or faster?
Yes.
So you offered to have him take a PBT test.
I did.
What would you have done if he would have taken the PBT test and it came back negative for alcohol?
He would have been allowed to drive on.
Did you make this stop intending to arrest?
No. So I could have arrested him anytime on any citation.
So you mentioned that when I first asked you about his speech, how did you describe his speech?
His speech was a little on the
I'm gonna
slow.
object, ask and answer.
Overruled. Overruled.
Overruled. Okay, so how did you describe his speech?
His speech was a little on a slur and slower response.
And how did you describe his eyes?
Glassy.
And how close were you when you first detected the odor of alcohol?
I was about a foot away from the vehicle,
Mhm.
and I never really passed the B pillar.
Okay. And when you detected the odor of alcohol, did you relate that back to your earlier observations?
Yes.
I have no further questions at this time.
Any recross?
Just briefly. You had never spoken to Mr. Harris before this incident, had you?
Not that I know of.
So you don't know how he normally speaks, do you?
Not necessarily.
He had a mask over his mask, didn't he? I mean, a mask covering his mouth while he was talking to you, did he not?
He had a cotton mask.
Okay. I believe you just testified that if he would have tested negative for alcohol in his breath, he would have let him just drive away, right?
He would have drove away with the citation for running red light.
Okay, no further questions.
All right, anything else for this witness, Mr. Tipton?
No, Your Honor. State rests at this time.
May this witness be excused.
Yes, Your Honor.
All right, Officer Stiggers, you're free to go at this time. Be safe.
Thank you.
Can we X this just so I can have a bigger screen, just to make me feel better?
Yes, of course.
All right, state may call its next witness.
Your Honor, state rests at this time.
All right, defense has witnesses to call in this case.
Your Honor, defense will not be calling witnesses or presenting evidence.
All right, I'll hear argument.
Thank you, Judge. Judge, as you well know, probable cause to arrest exists in Georgia when the objective facts known to the officer establish a probability that the suspect has been engaged in illegal activity. A probability is less than a certainty, but more than a mere suspicion or possibility. So under the totality of circumstances, you have to look at what evidence do you have that he was an impaired driver. One of the chief things the state is going to focus on is the fact that the officer testified that he ran a red light. With reference to that, I would like to call the court's attention to State v. Blanchard. That is a Court of Appeals case, May 18th, 2016. That's 337 Georgia App 130. And I want to, so in this case, the defendant had driven through a red light, and the officer, which was a fatal accident, and the officer had found a number of pills on him. In the analysis, the court indicates that the fact that a traffic violation occurred by itself does not establish probable cause that someone is under the influence of alcohol. Of course, you have to go to the totality of the circumstances. Additionally, Judge D'Amato v. State, which is in my motion, establishes that the smell of alcohol, even with an admission to consuming alcohol, does not establish probable cause to make an arrest for DUI. But the state is going to, I would anticipate that the state is going to argue that those two things together establish probable cause, Your Honor. However, you have the ability to assess the credibility of the witness in this case, and also to make determination if the officer had actually developed probable cause. Now, when he smelled the odor of alcohol, he indicated that he had a suspicion that he was possibly an impaired driver. However, he did not develop that suspicion further into probable cause there was no additional investigation that took place. He was immediately put into custody. He was immediately,
We're gonna skip over that whole PBT test?
yeah, no, Judge, I'll mention the PBT. So,
Well, I mean, because you can't go to, okay, red light, ran the red light, and then smell of alcohol. Those are not sufficient. And he did nothing else until he read him until he arrested him. If you don't tell me the case, tell me the case.
Sure, Judge. So when it comes to the PBT, as you're aware, a refusal to submit to a PBT test is not admissible under Elliott v. State. Additionally, he did.
Well, it might not be admissible, but it when you're talking about the totality of the circumstances, somewhere that has to factor in.
So I would disagree, Judge, because it is my client exercising his right not to produce evidence against himself, which the courts have held is not admissible and should not be used against a defendant in a criminal case.
I get that. But what you're asking for is a determination of whether what the officer perceived was sufficient. He may not have based his suspicion on the refusal for a PBT, but in the refusal for a PBT, your client then says, no, give me a blood test. And he indicated during the course of their discourse that he had been in law enforcement for 26 years. And so being in law enforcement for 26 years, he knows the implications of saying, oh yeah, well, don't give me this, the less invasive test, which we can do on the side of the road and I can be on my way, give me a blood test.
So Judge, I understand the point that you're making, but what I would suggest is that the fact that he didn't indicate that, or he didn't agree to take the PBT may have justified the officer in doing further investigation, but it does not itself establish probable cause, and it should not be considered in the totality of the circumstances. He also indicated that he would take a blood test, as you mentioned, Judge. So what you're left with, Judge, is a traffic violation. You know, I would object to the court considering the refusal and using that against Mr. Harris under the totality of the circumstances, because it is not admissible, and Georgia law says that that should not be considered.
I said, first of all, it might not be admissible, but you cannot escape the fact that certain indicators will factor into what an officer is going to consider. And I don't care what the case law says with respect to what is admissible at court, because you can't be in the officer's mind. But what I will say is you can't make this argument to me without at least mentioning he was offered a PBT, because even if it's not admissible, he was offered it. So that's an indication of further investigation. And when he was offered a PBT, even though he refused it, he then offers himself a blood test. He says, give me a blood test. And so that part, at least, arguably may be considered.
Okay, Judge, and I understand your point. I'm not going to go back and forth with you on that. We concede that he refused to take the PBT test. But the argument still remains, Judge, that
you're missing my point.
No additional evidence of impaired driving.
The PBT, but then he offers a blood test.
Judge, and I understand that, but the offer of the blood test, he agreed to it, but that is not evidence of his impairment. The state has the burden to prove that there was probable cause, not that he was a less safe driver, that he was a less safe driver because of the consumption of alcohol. Without the PBT, there's no that there was the present system beyond the smell of alcohol. There's no open containers indicating that he had consumed alcohol. There are no admissions indicating that he had consumed alcohol on that day. So, Judge, I understand your point about the PBT. However, the argument is still that the standard of probable cause was not met by this investigation. There was a traffic offense observed, according to the officer's testimony. He pulled him over. He said that he smelled the odor of alcohol, but there were no testimony about stations. There were no field sobriety tests to confirm the suspicion that he was under the influence of alcohol. There's no objective scientific testing to establish the presence of alcohol in his system. Judge, there was basically no investigation beyond the point of, I smell alcohol. Okay, you're not going to take the PBT. You're under the arrest. You're under arrest, Judge. So for those reasons, Judge, we're asking that you suppress the blood result in this case, any evidence that was obtained after the arrest, because the arrest was made without probable cause. And that's the argument, Judge.
All right, let me hear from the state.
Yes, Your Honor. So, Your Honor, with regard to the stop of the red light, I'd like to bring the court's attention to Landwehr, Lanwehr v. State. That's 265 Georgia App 359. In that case, running a red light was considered to be probable cause for the stop. Further, Your Honor, any type of traffic violation, even if it's just a single traffic violation, is enough for a stop. I'd bring the court's attention to Friedland, Freedland v. State, 223 Georgia App 326, which stated that a speeding is or any type of traffic violation would be judged for a stop.
I don't think we're questioning the probable cause for the actual stop. We're questioning probable cause for the investigation and arrest for driving under the influence, let's say.
Yes, Your Honor. And state was just getting to that point, Your Honor. The totality of the circumstances under Steinberg v. State, 286 Georgia App 417. The court must in these cases consider that the police officer had a particularized objective basis for suspecting that the person stopped was DUI. In this case, we have slurred speech. We have slurred speech. We have a very dangerous person. He is his eyes are watery. He's acting in a way that I myself consider to be kind of irrational, in that he was his volume was going all over the place. The officer went into detail about the smell, the slur, and the eyes. Now, the defense has honed in on an absence of standardized field sobriety tests. I wanted to bring the court's attention to Kellogg v. State, 288 Georgia App 265. In that case, there were watery eyes. There was an admission and odor of alcohol. That enough at a roadblock was reason for for probable cause to be found without standardized field sobriety tests. Here we don't have the admission of alcohol use, but we do have an unsafe act. Further, Your Honor, State v. Young, 334 Georgia App 161 includes that states that the court may consider driving behavior, refusal to take field sobriety tests, or an officer's observations. We don't have standardized field sobriety tests because of safety, exclusively because of safety. The officer was not attempting to circumvent field sobriety. In fact, field sobriety tests. In fact, he was willing to let the defendant go if he would have given a negative breath sample. If we look at Schlanger v. State, 290 Georgia App 407, visible manifestations on their own are sufficient to show probable cause. In our case, we have visible manifestations and an observed less safe act. Further, Your Honor, I do think that it is appropriate for the court to consider the refusal in this case, because it's not a refusal to make a statement. It actually stated that he would just make a different type of statement. Ergo, I don't think that Elliott would apply in this case. Our case is sufficiently different in that Elliott was a total refusal to make a statement. This is not a refusal to make a statement, but a decision to take a different test. And for that, Your Honor, the state requests that the court deny the defense's motion and not suppress any of the evidence. Thank you.
All right, so per the totality of the circumstances, the observation, the officer indicated that he initially dealt with Mr. Mr. Harris. He walked away to verify his information. He came back with the citation. As he got closer, he smelled the smell of alcohol on his breath. He said to Mr. Harris, "Hey, I smell alcohol on your breath. When was the last time you had a drink?" Mr. Harris responds with, yesterday. And so he said, yesterday. So he continues to talk to him, and he indicates that he felt like he was slurring his speech a little bit. He noted the glassy eyes, but he said that could have been because he was older. So he did not go straight to he's impaired. He said, I noted he had glassy eyes, but hey, that happens with older people. So that's a consideration of the factors as opposed to just jumping to a conclusion. He then talks to him about, would you, it's raining outside. Would you be willing to take a portable breath test? All the while the officer is talking to Mr. Harris, Mr. Harris has a running commentary. A Filipino girlfriend I was on the line with my Filipino girlfriend, and man, I've been in law enforcement for 26 years. I need just give me a warning. Just give me a warning. Oh my God. Oh my. And he is agitated. Talking about he's been in law enforcement. Just give me a warning. He's practically begging the entire time. The officer's demeanor never changes. He's straightforward. He's even a little bit lighthearted, kind of, like, hey, let's keep going with with what we're doing. So he's agitated. He's referring to having had other, he's just like, I can't get another ticket. Give me a warning. Give me a warning. So when the officer says, well, sir, if you're willing to take a portable breath test, then, I can give that to you here on the side of the road. And he says, no, I'm not taking a breath test. Get that. If you're saying it's a refusal subject to Elliott, fine. But what he then says is, no, give me a blood test. He makes the request. So the officer says, 4 more times, are you sure? Because it's just it's just blowing into the little tube. I can give you a PBT. No, I want a blood test. Are you sure you want a blood test? Yes, I want. He verifies it like 4 or 5 times. Then the other officer arrives on the scene. He reports to that other officer. He was like, yeah, I offered him a PBT, but he said he wants a blood test. So he said, we're looking at ran the red light, smell, slurred speech, glassy eyes, which he says could have been attributed to age, but that could factor in there. The agitation, the begging for a warning as opposed to a ticket. I'm in law enforcement, just talking the entire time. And so at this point, the officer says, well, sir, you've asked for a blood test. In order to do that, I have to put you under arrest, take you to the courthouse, take you to the jail. But I'm going to read you implied consent. He reads him the appropriate implied consent, verifies again, asks if if he, would take a chemical test, which is blood, and verifies again. And once again, the gentleman says yes. Even if we take out the PBT, the other factors, case law is replete with indicators of the other factors being sufficient for probable cause for further investigation after a traffic stop, especially if the traffic stop wasn't initially for DUI. There may not have been enough probable cause to stop him for being an impaired driver. But he did run through a red light in the middle of a rainstorm. So after he had probable cause to stop him, at that point, his indicators start to tally up. And so at this point, the court believes that the officer had the requisite probable cause to conduct the investigation that he did and to continue the investigation with respect to reading him implied consent and noting that he believed that Mr. Harris was impaired. And so at this point, this court is going to deny the motion to suppress.
Thank you, Your Honor.
You're welcome.
Judge, I believe that concludes Lister and Holt's business today. May we be excused?
You may. All right, for those of you who are here for the 11 o'clock calendar, thank you for your patience. Motions take a little bit of time, so at least you've had an opportunity to see what we do here. The traffic bench trial, I'm going to call the traffic bench trial, and if you are here for the traffic bench trial and you have several options. So you can, of course, go to trial. We will check with the state, we'll check with you to see if you are ready for trial. Otherwise, if you wish to speak with the state, we have two solicitors, and if you wish to speak with them prior to trial about a possible plea to resolve your case, you may do that also. You may do that if you're representing yourself. You may do that if you are being represented by counsel. So all of these are available to you. If you have a trial, please understand that you're not required to present any evidence or testimony. The burden to prove the case against you is the state's burden, and I will remind you of that at the time of the trial. First case on the calendar is Lewis Edward Billingsley. Lewis Edward Billingsley.
Not here. Your Honor, he's present in the courtroom.
All right, Mr. Billingsley, you're charged with speeding 16 to 20 over the limit. Do you wish to speak with the state to see if you can resolve the case, or do you wish to go forward with trial?
I go forward with the trial.
Okay. All right. Is the state ready for trial?
Yeah, are we doing it right now?
The state is ready. The officer is on Zoom.
Yes, sir.
Yes. I drove 3 hours because I don't trust those Zooms.
Okay, that's fine. Mr. Billingsley, let me finish calling the calendar, and then we'll call you up when your trial is, when you're ready for your trial.
Okay.
All right. Caldwell, William Lorenzo Caldwell.
He's on the way up, Your Honor. He's walking up.
Your Honor, the state is moving to no across his case, his citations.
All right, Mr. Caldwell, you're before the court on citations for seatbelt violation 2024 TK 15453, equipment tire failure 2024 TK 15456, and failure to, it just cuts off at that point. Failure to, I guess, update license address.
Yes, Your Honor, failure to change address.
Okay, and that's 2024 TK 15457. You and the state have come into agreement on these issues, and all three will be no pros. And so you're free to go at this time.
Thank you, Your Honor.
Excuse me, Your Honor.
Yes, sir.
I really wanted to do a trial. I don't want the state to no pros me. I want y'all to hear, like, I want the state to pick up what they started. I'm sorry, in all respect.
Okay, do you know what the no pros means, or do I need to explain that?
I mean, basically, they threw it out. They don't want to prosecute. I understand.
Yes, but you want to try the case and risk a conviction on any of these offenses.
I think the state know what, I mean, it's no way. I'm sorry. They okay, no, I'm gonna take it. Thank you. So it's all thrown out, right? It's all thrown out. Man, I'm sorry because I waited.
That's okay. Some people want to exercise their inner Clarence Darrow. They want to come in here and be Matlock.
No. I waited a year for this, and like mentally, I had to call up here to even get in court. Mentally, I
got you, sir. We're working on being better with respect to these cases, and some of them are pretty old. Yours are pretty recent. So actually, you've actually gotten to court a lot quicker than some cases. But we are still, and I hate to say it, but we're still suffering a backlogs in some cases from COVID. So as you know, we shut down, but the cases kept piling up. All right, well, sir, thank you. You're free to go at this time. Please be safe.
Thank you.
You're welcome. Philip Daniel Chapman.
President of the courtroom, Your Honor.
All right, Mr. Chapman, come on up. Mr. Chapman, you're charged with speeding 16 to 20 miles per hour over the limit. Sir, did you wish to go to trial, or did you wish to speak with the state about a possible resolution?
I'm ready for trial, but I can talk to the state first.
Okay, the state ready for trial?
State's ready. Mr. Tipton, that's one of your cases.
Yes, Your Honor, I need to step back into my office to review the files to see who we've got present at this point. I just was waiting until the court called the calendar so I could.
Okay, go, just let me know when you're back in your office and I'll resume the call. All right, Mr. Chapman, just hold on for me for a second. He's gonna walk out.
Okay.
Oh, that's all right. Please tell her, please. I mean, he's in, female cell. I'm gonna get them to. She in the female cell. Yeah. 1, 2, 3. How long?
All right, I'm just holding until Mr. These earlier the lower alphabet letters are Mr. Tipton's, and when we get into the higher alphabet letters, those are Miss.
Your Honor, I'm back in my office.
All right, so Mr. Tipton, are you all ready for trial on Chapman?
I apologize, Your Honor. I had my computer muted from when we were in the courtroom.
Okay, are you ready for trial on Chapman?
Your Honor, state's moving to null pros this case.
All right, Mr. Chapman, your case is being null prosser, and you're free to go at this time. Please be safe.
Thank you.
You're welcome. Janiyah Monique Clark. Janiyah Monique Clark.
Your Honor, state's ready at this time for Ms. Clark. The calendar started at 11. We would ask that a failure to appear be issued.
All right, I'm checking the video screen just in case she's having technical difficulties. I do not see Ms. Clark. Last call for Janiyah Monique Clark. All right, the state will, the court will grant the state's motion for a failure to appear.
Thank you, Your Honor.
Next is Sabre Una Cotton.
Here, Your Honor.
All right, Ms. Cotton is present. Is the state prepared for trial?
And I'm here on behalf of the defendant. My name's Ben Hancock.
Okay, Mr. Hancock.
I would like to bring to the court's attention that in a civil matter, a 68-page deposition has been taken of the other driver involved in this incident. And I believe that that transcript is very compelling. And
Okay, I think that would be for pretrial negotiations until such time as y'all have a trial and that transcript information is admitted. So if you want to present that to the state to see if y'all can negotiate something, that's fine. But I asked the state to announce whether they're ready. Ms. Ponder, is this your case or Mr. Tipton?
Your Honor, that would be Mr. Tipton's case.
Okay, Mr. Tipton.
Is Officer Cansfield present? Mr. Canfield? State's moving to null pros, Your Honor.
All right, case will be no pros. Anything else, Mr. Hancock?
is this matter dismissed?
It's no pros, yes, sir.
No, nothing further, Your Honor.
All right, you're free to go.
Thank you.
Ms. Compton, you're free to go.
Thank you.
Andre Dennis, that case is closed. Michael Antoine Dunlap. Michael Antoine Dunlap.
Your
Last-
Honor,
Yes.
it's going to request a failure to appear be issued.
Last call for Michael Antoine Dunlap. Failure to appear will be granted. All right, next is Dominique Lynn Fitzpatrick. Ms. Fitzpatrick is present. Is the state ready for trial?
Is Officer Ferguson on? Officer Bryant Ferguson? I'm sorry, I think I may have heard something. Was that Officer Ferguson? Okay. Your Honor, I don't think Officer Ferguson's present. State's going to move to null pros.
All right. Ms. Fitzpatrick,
Mhm.
your case is being no pros. You're free to go at this time, ma'am. Please be safe.
Thank you.
You're welcome.
It's my birthday. Oh gosh, thank you.
Oh, happy birthday. Mine was this past week.
Oh, thank you. Thank you. Have a good day, y'all.
You too. All right. So Christian Shade Hooper.
State's going to request a failure to appear, Your Honor.
I'm here.
Yeah,
Present.
All right.
It's Sade, just like the singer. Yes, ma'am.
So Miss Hooper is present. Is the state ready for
Eric, can you just come assist me, please?
Miss Fitzpatrick, hold on. I think she was calling her tech support, probably a young person. It is summertime. All right, is the state ready on Hooper? Miss Hooper has 1, 2, 3 cases.
Is Officer Ray Ford present? Officer Ford? Your Honor, I don't see Officer Ford on the call. State's going to null pros this case. These
All right.
cases, excuse me.
Miss Hooper, your cases are going to be no pros. Please be safe. You're free to go at this time.
Thank you. Happy belated birthday.
Thank you.
Have a good one. Bye.
All right. Alante Pearl Johnson.
I'm here.
Oh, okay, Miss
You
Johnson.
said it right too.
All right. The state ready on Miss Johnson.
Yes, Your Honor. Officer Kirilova is present.
All right. So Miss Johnson, you have the option of going forward to trial or speaking with the state to see if there's something you can resolve for the improper lane change. Did you wish to speak with the state or did you wish to go forward with trial?
Would I be able to do both if it doesn't?
You can speak with the
resolve?
state, yeah, and if you don't resolve it, you can go forward with trial.
Okay, I'll let you speak with the state then.
All right, thank you.
No problem. Thank you.
Eddie, I want to say it's Eddie Johnson, Eddy. I don't want to get caught up and it's actually Edie, but it's Eddy, Joseph. I'm sorry, Edie Joseph or Eddie Joseph.
My honor, it's Eddie Joseph.
All right, thank you. I'm sorry. All right, so is the state ready on Joseph?
Is Officer Kearney? I don't think I see Officer Kearney.
He's here. I see big old Navy.
Oh, there's Officer Kearney.
Big
Okay.
old Navy insignia.
I got you. State's ready, Your Honor.
All right. So Mr. Joseph, same option. You can go forward with trial, state's ready, or you can talk to the state and see if there's a resolution that you all can agree to on stop or yield sign violation.
My honor, so let's hear what the state.
All right, so I'll put you in for a conference with the state in a moment. All right, next is Destiny Marie Meyer. Destiny Marie Meyer. It's Meier, Destiny Marie Meyer. Okay, I'm checking the video. I don't see anyone. I don't see anybody in the courtroom. Destiny Marie Meyer, what's the state's announcement?
State requests a failure to appear be issued.
All right, failure to appear will be granted per the state's motion. And next is Derek Jonathan Roseberry. Derek Jonathan Roseberry. Mr. Roseberry has 2 cases. Derek Jonathan Roseberry.
Your Honor, I don't see Mr. Roseberry present. State would request a failure to appear be issued.
Last call for Derek Jonathan Roseberry. Mr. Roseberry will have a failure to appear ×2. All right, next is Travis Smith. Travis Smith. Travis Smith.
Your Honor, I don't see Mr. Smith. State would request a failure.
Last call for Travis Smith. Failure to appear will be granted. All right, Dennis Carlton Touchstone. Dennis Carlton Touchstone.
Yes, ma'am.
All right, Mr. Touchstone is present. Is the state ready on Mr. Touchstone's case?
State may sound as Officer Brandon Marshall present. I don't see Officer Marshall on here. Officer Brandon Marshall. Your Honor, state's going to move to null pros.
All right, the court is going to grant the motion to null pros. Mr. Touchstone, you're free to go at this time. Please be safe and slow down for me, okay?
All right. Thank you, ma'am. Happy belated birthday.
Thank you. All right, and that's ×2 on Mr. Touchstone's case. All right, so we have conferences on Johnson and Joseph. We have trial on Billingsley. Is Mr. Johnson and Joseph, is that Ponder or is that
That will be me, Your Honor.
Okay, so we're going to go forward with Mr. Billingsley's trial. Let me go ahead and get you in a conference with Mr. Joseph and Mr. Johnson, or with Johnson and Joseph. I'm sorry, I think Miss Johnson and Mr. Joseph.
Your Honor, I believe they're all technically my trials. May I take Mr. Billingsley's documents over to Miss Ponder?
Oh, Mr. Billingsley is a trial, so you're gonna let Miss Ponder do that trial?
Well, I can handle it. Your Honor.
No, that's fine with me. I'm just clarifying.
And I can speak with whoever needs to negotiate. Mr. Tipton can handle the trial for Billingsley.
Okay, sounds good. So I will put Miss Johnson and Mr. Joseph in a breakout room with Deputy Chief Ponder. Then that will allow Mr. Tipton to do Mr. Billingsley's trial, and that way we don't hold everybody, because y'all have been so patient. We don't hold everybody unnecessarily. So let me go ahead and set up the breakout room.
Your Honor, I've been with this over 1.5 years.
Hey, sit down. Sit down.
I got you, sir. We're coming. We're moving as fast as we can. Ms. Johnson, I'm going to put you in breakout room number 1 with Deputy Chief Ponder. And if you all agree to anything, let me know. Yes, yes, on the Smith case, yes, he did receive an FTA. So Officer Phelps, I believe, is asking to be excused, Mr. Tipton.
I believe that he was on Travis Smith, who got an FTA, so he should be free to go.
Okay.
And
all right,
I'm going to take these tickets to Miss Ponder real quick. She's literally right down the hall from me.
All right. So thank you, Officer Phelps. Be safe. Mr. Billingsley, we're ready. As soon as Mr. Tipton gets back to his office, we'll be ready to start your trial. Okay.
Thank you.
You're welcome.
Thank you, Your Honor. I'm back.
All right. So, Mr. Billingsley, if you'll come on up for me. So you can come on up to the computer. That's the best way to hear you and see you.
Okay, thank you.
All right. So I'm gonna put Mr.
And Your Honor, so Mr. Billingsley is aware the state would offer to reduce his speed to 80 and a 65.
All right.
And the state would offer to reduce his ticket to 80 and a 65, and it'd be a $100 fine if Mr. Billingsley would like to take that offer.
Mr. Billingsley?
That reported on my license?
It would be, sir. It's 15 miles over, so it would be reported.
No, I'm going to court. I'm going to trial.
All right. So, Mr. Billingsley, can you see Mr. Tipton?
Yes.
Can you hear me?
Is that the DA, Mr. Tiffany?
It's the solicitor, yes.
Yes, okay.
All right. So this is case 2024 TK 00106. Louis Edward Billingsley. You're before the court for speeding 16 to 20 miles per hour over the limit. Mr. Billingsley, Ms. Johnson, I'm sorry, let me try that again. So, Mr. Billingsley, the state has the burden of proving the case against you beyond a reasonable doubt. You do not have to provide any evidence or testimony. You do not have to testify in any way or present any witnesses. But you do have the right to ask questions of any witness brought by the state. So what that means is you wouldn't make any statements, but you would just ask questions about their testimony or about the situation so that I would be able to understand what it is you want me to know about what happened. So let's try to avoid making any statements or saying things like, well, really what happened was, or what I observed, because you have the right to remain silent. And until you decide to give up that right to remain silent, then we don't want you to make any statements and jeopardize that right. You understand?
Yes, ma'am, I do.
All right. So the state's going to present their witnesses. After they finish questioning the witness, you'll be able to question a witness, and then we'll go from there. At the end of the trial, whether you make a statement or not, whether you wish to testify or not, each side will be given the opportunity to make an argument to explain to me why I should rule in your favor. Okay?
Yes, ma'am.
All right. So, Mr. Tipton, call your first witness.
Yes, Your Honor. State's going to call Officer Jeremy Parks.
All right. Officer Parks.
Good morning.
Good morning, Officer Parks. I got that, Mr. Billingsley. Hold on just a second for me. Officer Parks, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
I do.
All right. You can put your hand down. All right. Mr. Tipton, your witness.
Yes, Your Honor. Officer, would you please state your name for the Zoom?
It's Officer Jeremy Parks with the Clayton County Police Department.
How long have you been with the Clayton County Police Department, sir?
A little over 3 years now.
And what's your official title?
I'm a field training officer.
Okay. And as a field training officer, are you post-certified?
I am.
And being post-certified, are you authorized to issue citations and make arrests and investigate crimes?
I am.
Okay. So when did you become
August of 2022.
Okay. So I want to draw your attention to December 21st of 2023. Were you working with Clayton County PD?
Yes,
Were you post-certified at that time?
I was.
Okay. And you have to do a certain number of hours to keep that certification up. Is that correct?
Yes.
Okay. Were you up to date at that time?
Yes, I was.
Okay. Okay. So did you have occasion to, well, let me ask you this. What were your duties that day?
Answering calls for service and traffic enforcement.
Okay. Did you have occasion to perform traffic enforcement on I-675 near Highway 42?
I did.
Okay. And during that, at that location on that date, did you have occasion to make contact with Mr. Lewis Edward Billingsley?
I did.
Okay. And do you see Mr. Billingsley on the Zoom call?
I do.
Can you identify him by an article of clothing he's wearing?
He's wearing a yellow shirt.
Okay. Thank you. So why did you make contact with Mr. Billingsley?
So I was traveling southbound on I-675, right at the Forest Park, between Forest Parkway and Highway 42. And I observed a vehicle traveling at a very high rate of speed. The speed limit being 65 miles an hour on 675. I got behind the vehicle and caught up to him, and I was able to pace his speed at 90 miles an hour. And then I conducted, a traffic stop by activating my emergency lights and pulling him over to the right shoulder.
Okay. Was your speedometer working that day?
It was.
Okay. How did you know it was working?
It's tested through Clayton County's maintenance program.
Okay. Okay. And was this portion of I-675 within the boundaries of Clayton County?
Yes.
Okay. And when you made contact with Mr. Billingsley, did he make any statements to you?
He did. I explained to him the reason for the stop, and I told him that I had paced him doing 90 miles an hour, and he said, "No way I was doing 90. I was doing 85." And I said, "Well, the speed limit is 65, sir." And he said, "Oh, it's 65 here. I thought it was 75." And I said, "No, sir, it's 65." And then I went to my car and I wrote him a speeding ticket for doing 85 miles an hour in a 65 mile an hour zone. When I returned to give Mr. Billingsley the ticket, he said, "I hope you know what you've done. I'm a CDL driver. This is gonna mess up my career." And I explained to him that as a CDL driver, you have to know better. And I told him to have a nice night and drive safe.
See. Okay. Thank you. At this time, I have no further questions for you, sir.
Mr. Billingsley, do you have any questions for Officer Parks?
I do.
All right, you may ask those questions. Ask them one at a time, allow him to answer, and then proceed with your next question.
Okay, Officer Parks, hello, how you doing?
I'm fine.
When you got on the interstate, were you coming on an on-ramp to the interstate?
I did get on the interstate from an on-ramp, yes.
Yeah, and what ramp was that?
I don't recall.
It was 2.
Objection, Your Honor, that's testimony.
Okay, so Mr. Billingsley, that's testimony. That's what we were cautioning you about. You can't tell him what to say, but you can ask him questions to elicit his response. And if he doesn't know, he doesn't know, so.
Okay. Well, could you see, you saw me when you got on the ramp?
I don't believe I saw you from the ramp. I believe I saw you as I was driving on 675 southbound.
Do you believe I could have seen you from where I was?
Objection, Your Honor. Calls for speculation.
Overruled. You may answer that, Officer Parks.
I can't speak to that. I don't know. I wasn't stationary on the interstate. I was driving to another place on the interstate when I observed the vehicle driving at a high rate of speed.
Okay. When you pulled me over, what was the first thing you said to me?
Hey, how's it going, man? I'm Officer Parks, the Clayton County Police Department. I stopped you because I paced you doing 90 miles an hour in a 65 mile an hour zone.
Okay. Your Honor, the conversation was a little bit different.
Okay, so Mr. Billingsley, if you're done asking questions of Officer Parks, then allow the state to finish presenting their case. And then if you wish to testify, I'll go over with you your right to remain silent and whether you're willing to waive that right. And then if you do waive that right to remain silent, then we'll hear your testimony.
Oh, okay. All right. Okay, Officer Parks. Okay, after you gave me the ticket, how did you give me the ticket?
What are you asking? I'm sorry.
What kind of a ticket did you give me?
I gave you a written citation on our Brazos e-citation machine.
It's like a phone,
Yes,
and I just signed the phone.
correct.
Okay. After I got back on the interstate and you got back on the interstate, did you get off on the next exit?
I probably got off on either exit 1 or 2 because that's the end of our county.
How far were you on the interstate from the time you got on it to the time you got off of it?
So Clayton County runs from exit 7 to exit 1. So that's the length of that's how far I would have went.
Okay. So if I was to say you were on exit 2 to 1, how far would that distance be?
From 1 to 2, I don't know.
Okay. Would it be a mile? Could it be a mile?
It could be, but I don't know for certain.
Okay. How much time do you, in the training that you've had for pacing somebody, how much distance do you need to travel to accurately pace somebody?
There's no set distance.
No set distance? Okay, let me ask you something. What's more accurate when you're gonna give somebody a ticket? Is it radar, laser, or pacing? Which is the most accurate way to give somebody a ticket?
Your Honor, this is irrelevant. The officer's already said he's paced him. There's no point in bringing up these other methods of detecting speed.
That's a question.
Hold on, Mr. Billingsley. So Mr. Billingsley is on cross. He's entitled to a thorough and sifting cross. I'll let him have a little leeway. Mr. Billingsley, when I feel like you're going too far, I'll stop you.
Thank you.
So at the time, I wasn't LiDAR or radar certified. I am now, and I can say that I would primarily use LiDAR. However, pacing is still a good option if need be.
Okay, which is the most reliable is what I'm asking.
I can't speak to that. I don't know the science on it.
You're trained in radar as well?
I am.
And laser?
Yes, sir. I am now. I was not at the time.
And pacing?
Yes, sir.
What are the requirements when you're learning when you're in training of pacing?
There is no
pace?
I'm sorry.
How do you train to pace? Is there a depth perception and time and travel, all that's involved, right?
There's no specific requirements for being able to pace someone for speed.
No requirements for pace. Okay, that's a good answer. Was it dark?
Yes, sir.
Is it easier to pace somebody at night or in the day?
It's the same, sir.
It's the same.
Yes, sir.
Perception's no different. You know, I used to. Okay.
Objection, Your Honor. This is testimonial.
Okay. It's a question. Headlights. I'm asking him a question. Headlights look the same whether it's nighttime or daytime.
I wasn't looking at your headlights, sir. I was looking at your taillights.
Taillights too, to any kind of lights at night. Are the lights, they look the same in depth perception and distance at night as they do today?
Yes, sir. I've been on the same shift for the last 3.5 years.
I rest my case right there, and then
Sir, the state's actually presenting their case. Your case hasn't started yet. So, all right, Mr. Tipton, did you have any redirect?
I do, Your Honor. Officer Parks, were you wearing a body cam that day?
Yes, sir.
And did the body cam capture the entire interaction?
Yes, it did.
Would the body cam have captured the interaction where he said that he was doing 85?
Yes, sir. Which is why I wrote him for 85 miles an hour and not 90.
Your Honor, may I share my screen?
You may.
Okay, I just want to make sure we're sharing audio. Is the court able to hear?
Yes, I hear.
Hey, how's it going, man? I'm Officer Parks of the Clayton County Police. Hey, turn it down. turn the radio down.
Officer, I wasn't even paying attention to it.
I'm clear. So, is there any reason we're doing 90 on the expressway?
Officer, I'm telling you, I was doing 85 according to this.
Okay, so 85.
Yeah.
I got you. You got your ID on you?
Yeah.
What's the speed limit? 65.
Oh, that's 65 here?
Absolutely. All day
Well,
long.
man,
There's signs all over the place.
I've been away from home for 2 weeks, and I've worked all. I just got off work, man.
I got you.
And I'm trying to get home, man. I'll tell you.
Where's home at?
Fitzgerald.
I got you.
I'm so frustrated and everything. Hold on, I got it.
Mr. Parks, what did that just show?
It showed Mr. Billingsley admitting to driving 85 miles an hour in a 65 mile an hour zone.
And what did he say? He saw that. What did he say he was going by to determine his speed?
His speedometer.
And did he give you a reason why he was going that fast?
He was just trying to get home. He'd been gone for 2 weeks and wanted to get home to Fitzgerald.
Thank you. No further questions.
All right, Mr. Billingsley, did you have any additional questions for Officer Parks?
Yes, there was. How many speed signs are on I-75? I mean, on I-65 that say 65 miles an hour?
I don't know exactly how many there are, but there's usually one at the beginning of the interstate and usually one after each exit. But I can't say for certain how many there were that night.
Yes. Could it be more than that, you say?
I really can't speak to how many were there that night. I can only tell you what there usually is.
Yeah. Did you tell me that they were all up and down there? They were marked all over the place?
Yes, sir, I did.
And but you don't know how many there were?
I don't.
Yeah. You're saying that they are many, though?
I'm saying that there's more than one.
Okay. At that point, more than one. Okay. What time of the day was this?
It was at nighttime.
Was there a lot of traffic out there?
No.
Okay. I cannot, well, I'm gonna, I've got more to say, but it's hard to do it in this kind of setup right here. So what's next?
All right, so we've finished with this witness. Mr. Tipton, did you have any other questions of Officer Parks?
No, Your Honor. At this point, the state rests.
All right, is Officer Parks able to leave at this time?
Yes, Your Honor. Thank you, Officer Parks.
Thank you.
Officer Parks, you're excused. Be safe. All right, so Mr. Billingsley, the state has rested their case. They've presented the testimony of Officer Parks. They presented the body cam evidence from the night in question. Sir, did you wish to give testimony in this? Please remember that as I instructed you, the state has the burden of proving the case beyond a reasonable doubt. You're not required to give any evidence or testimony. You have a Fifth Amendment right against self-incrimination. However, if you do want to give up that right and offer testimony and evidence, the court will hear it.
Yes, I would give up that right.
All right, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, I do.
All right, put your hand down, sir. Tell me what happened.
Okay. I was, my argument here is, there's only one sign. I went back and looked. There's only one sign that said 65. And, you know, you can easily miss it by one semi. There was two semis, you know, that I was kind of traveling with. We were all kind of going the same speed. I observed this officer coming on to 675. I saw him coming on. So why would I speed? Well, I think, you know, intention. Now, when he got behind me, he was about like a football field behind me, 300 yards. And then he was catching up with me. I shot, he pulled me over. So when he pulls me over, he, you know, caught me off guard. He's like, what are you doing 90 for? I wasn't doing 90. I had been doing 85, and I know that was speeding because I was trying to get home in 75. And why would it be? It could easily be missed, that speed sign. There's only one. And he got, my argument is that is exit 2. He got on exit 2 and pulled me over before he got to exit 1. He got back off of exit 1. That's 1 mile. And I don't think he had enough time to accurately pace me, other than me being honest about what I was doing previously. I was never doing 90, never. So his voice, and when he come out there and said, you did 90, he was catching up with me. That was his speed, to catch up with me. He's never on my taillights. I would love to see, and I asked before when I came to the to say I wasn't guilty, for the discovery of the vehicle's camera, to show, that would show his speed and when he got on and when he got off the ramp. He was only on for not even a mile. It was 1 mile between exit 2 and exit 1. And my argument is he didn't have enough time, Your Honor, to accurately clock me or pace me to get an accurate speed. Yeah, he did. He said he gave me what I admitted to, but that's what I had been doing before. Also, there's only one 65-mile-per-hour sign. As I went back and looked at it, there's not many, like he said. So there's just some inconsistencies here, Your Honor. Also, I have a CDL because I drive children. I'm the backup driver for the school swim team, and without me, there's not going to be a swim team. And that's what I asked him before when I was telling him about my CDL. Yeah, this is going to, you know, like I said, now that was one of my concerns right there. My only concern, and I was willing to pay for that $100, was it being reported on my license, because for the school system, that's it. You can't do it. And I had a daughter that was on the swim team, and I was the backup driver on that. So that's what I was referring to him about. Wasn't about any other thing else. You know, I have a good driving record, and I had been away from home for 2 weeks. I had all my stuff in that vehicle, and I was trying to get home. It was 2 days before Christmas. I had Christmas music going, and he hollers, "Turn that music off." I was like, you know, I was trying to have a nice trip home. You know, I had a 3-hour trip ahead of me. I drove 3 hours to get here. And, but I'm just saying there's some inconsistencies, and I did look up some case law about some that's been dismissed. I didn't bring that up, but at nighttime, you cannot have the depth perception he said was the same as it is during the day. It is not. I used to work on the railroad, and that headlight you would think is a mile away, and it's more like 100 feet away. You cannot have the same depth perception on you can today, and that is something that he said had made no difference. So that's another argument that I have right there. But just the inconsistencies, and that's why I'm here today, saying there, and the fact that it was a pacing ticket at night, no traffic, and it was a one speed sign could easily be missed. So, and that's what I have to say right there, Your Honor.
All right, Mr. Tipton, argument?
Yes, Your Honor. Your Honor, ignorance of the speed limit does not excuse one from driving the speed limit. The officer testified that there were signs at the entry and exit ramp for every entry and exit point on I-675. The court did observe the defendant admit to driving 85 miles per hour and admit that he had been viewing his speedometer. Your Honor, if we were to, if the court takes into, I think it would be inappropriate for the court to take into account the defendant's CDL, as Your Honor is aware of the anti-masking laws. Your Honor, based on the facts of the case, based on the defendant's own admission on tape, based on everything the officer stated, the state would request that the court find the defendant guilty of speeding 85 and a 65. Thank you.
All right, so Mr. Billingsley, I understand the argument that you're making, but Mr. Tipton is correct. I could lose my position on the bench, and it would be illegal for me to consider the fact that you're a CDL holder and making my decision when the law, particularly when the law suggests to the contrary. The officer has testified that he paced you. He indicated that he paced you at 90. He pulled you over. When he pulled you over, it may have seemed like he was yelling to you, but to me, it appeared that he was just trying to be heard over the Christmas music. And so he asked you, hey, you were going 90 out there. No, I wasn't. I was going 85. And then there was the information about there being some confusion about the speed. However, the old axiom is that ignorance of the law is no excuse. And so even if the speed limit had been 70 or 75 on that highway, you still would have been exceeding the posted speed limit per the law. And so in this case, the court will find you guilty. The officer said he paced you at 90, but he did not write the ticket for 90. He wrote it for 85, which is the speed that you admitted. You also admitted that here in court, as you did on the body cam video. So the court is going to find you guilty of the speed of 85 miles per hour in a 65 mile per hour zone. And Mr. Tipton, do you have a recommendation for the penalty?
A $300 fine, Your Honor.
All right, Mr. Billingsley, I generally don't like to, give people a higher penalty just because they went to trial. So the offer, I guess, initially was $100 fine. The fine with the $100 fine with the surcharges would be $151.50. Did you wish to pay that today or have additional time?
Yeah, I'd pay it today.
Okay, so it's $151.50. When you leave the courtroom, you'll go downstairs to the second floor. When you come back through the double doors, you'll go to your left and you'll see the traffic court window. There they will accept your payment and they'll give you your paperwork as a receipt. And you'll be free to go after that time. Just don't leave the building without making that payment, okay?
Okay, they take credit card?
They do, sir.
Okay.
All right. Take
Thank
care.
you for your time.
You're welcome. All right, so I believe, unless I missed something, that concludes the 11 a.m. calendar. It is Yes.
Mr. Egg Joseph, I was
Oh, that's right. Announcements. Go ahead, Ms. Pond.
attempting to have a breakout room with him when I joined. I didn't see anyone, but I am messaging him via the chat.
Okay, because I thought I put y'all in three because I was trying to move you so you would get a invitation, and he would get an invitation. I'm sorry. All right, did you have an announcement on Johnson?
Yes, Your Honor. Ms. Johnson would like to take a plea, and I have her email address, Your Honor,
Okay. Ms.
to
Johnson.
provide to Ms. Wright.
All right, so Ms. Ponder, let me know when you're ready for the plea on Ms. Johnson and the announcement for Mr. Joseph.
I'm ready on the plea for Ms. Johnson, Your Honor, and I'll stay in communication with Mr. Joseph.
All right, on each of those cases, I know there are officers present. Just let us get the plea on the record, and then once we do that, you all will be excused at that time. All right. So Ms. Johnson, may I see you, please?
Yes, ma'am. Right here.
Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. All right, so this is State of Georgia versus Alante Johnson. Ms. Johnson, you are before the court on 2024's TK 01531 for improper lane change. Ms. Johnson, it is my understanding that you are representing yourself in this matter. Is that correct?
Yes, ma'am.
Are you over the age of 21?
Yes, ma'am.
All right, and what have you, Ms. Ponder, what have you and Ms. Johnson agreed to with respect to the improper lane change?
A $100 fine, Your Honor.
All right. All right, so Ms. Johnson, is she NOLO eligible?
She is, Your Honor.
All right, Ms. Johnson, are you choosing to enter a NOLO plea at this time?
Yes, ma'am.
All right, by entering a plea of NOLO, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present evidence and testimony on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right. Factual basis and recommendation, please.
Yes, Your Honor. On January the 16th, 2024, officers conduct a traffic stop on Holiday Boulevard and Nassau Street, located here in Clayton County, Georgia. Officers observed that the defendant did make a right heading towards east on Holiday, making U-turn with no room for U-turn right at three-way stop sign, getting off of the road. And those are the facts of the case.
All right. All right, ma'am, it's $100 fine. The total fine with the surcharges is going to be $151.50. I give people who are not at the courthouse at least 30 days to pay. Do you need more than 30 days? I can give you up to 60 days to pay.
No, 30 days is fine.
Okay, so Ms. Ponder is going to send your email address to Ms. Wright, my court clerk. Ms. Wright's going to send you back an email with the date by which this needs to be paid. It's also going to have information about how to pay online or by phone if you choose to do that, or you'll come into the courthouse at 9151 Terra Boulevard in Jonesboro, Georgia, and make your payment on the second floor. Okay?
Yes, ma'am.
All right, so be safe, Miss Johnson. Check your email in a day or so. And if you don't see it, look for your spam folder, okay?
Yes, ma'am. Thank you.
All right, take care. Be
All
safe.
right, you too. Happy belated.
Thank you.
No problem.
All right, and for Joseph.
Yeah, Sharon, he just asked a question. I've just responded, so hopefully.
No problem. Just let me know when you're ready.
Okay. Thank you, Renner. And are we?
So, ladies and gentlemen, if there's anybody here for the 1 o'clock calendar, we're just going to hold for a moment until like about 5 after 1. If we're doing video calendars, I like to have people have the opportunity to get on to work out all the technical kinks. So if you're here for the 1 o'clock calendar, just be patient. We're going to call that calendar after 1 o'clock, about a little bit after 1 o'clock, so that we can make sure everybody's here.
And Your Honor, for the announcement for, I think it's Jania or Jania Clark, what was that announcement?
It was an FTA.
Oh, FTA. Okay. Thank you, Your Honor.
I'm sorry, this is Officer Kirilova. Can I be excused?
Yes,
I
were
have
you
a
on
question, Johnson.
the Johnson? Yes, ma'am. Yes, ma'am.
Thank you. Have a good day.
You too. Be safe. Hi, Mr. Smith.
Good morning, Your Honor. I was here on Mr. DeCory Johnson. He's on the 1 o'clock suspended sentence calendar.
Okay. He hired an attorney to tell me whether he's gonna pay or not.
He's in jail. He's actually
Oh.
incarcerated on this charge only, but I'm representing for another case that he has that's scheduled for June 23rd. But I told him I would come in and
Okay,
say hello.
how long has he been in jail, Mr. Smith?
Since 5/7/2025.
Okay, so Miss Powell, may I have a modification? Credit for
Yes,
time
Judge.
served on his SSD?
Yes, Judge. Will you tell me the last name of the defendant?
Last name is Johnson, case 2021 CR 08912.
Okay,
Corey,
yes, ma'am.
I'm sorry, Tecorey, Tecorey.
Got it.
All right.
I'll get that right over to you.
Okay, so Mr. Smith will do a modification, give him credit for time served in lieu of the $440, which is the balance.
Thank you, Your Honor. And will you guys send that to the jail, or do I need to
I'm
send
gonna
it on?
sign it and then I'll send it to everybody who needs it.
Thank you so much.
You're
Have a great day.
welcome. You too, sir.
Bye.
Your Honor, I have an announcement on Mr. Joseph's case.
What's your announcement, Ms. Ponder?
Yes, Your Honor. So I've been in communication with Mr. Joseph. It doesn't appear that we have been able to come to a resolution. I've explained to him, Your Honor, that I cannot offer him legal advice between a guilty and nolo. I did explain to him that the state would not object to a nolo plea. He then began to ask about points on their licenses. So the state is ready at this time so that we do not have the officer still waiting.
All right. So Mr. Joseph,
Your Honor.
okay, is that your only concern?
Yeah,
Is
I
a
just,
NOLO? Okay, let me see if I can explain the difference. So a NOLO plea allows you to avoid points on your license as long as you are NOLO eligible. As long as you have not used a NOLO for the same or similar offense in the last 5 years, then that should allow you to avoid points on your license. The reason you can only use it every 5 years is because it's a kind of a one-shot deal. Get the opportunity to use it and avoid those points, and hopefully it cautions you about the next time. If it's a guilty plea, there may be points associated with a moving violation. But if you're able to use a NOLO plea, there should not be any points assessed by the Department of Driver Services, as I understand their policy, for a moving violation.
so Judge, thank you for this. And just for the clarification, in terms of the ticket as it stands, it says stop or yield, sign violation. What is there, or are there points associated with this?
I can only assume that there would be points because it is considered a moving violation.
Okay, so and what are those points? Because I
do
want to
not
be able
know. I
because I
cannot
want to
tell
be
you
able
that.
to make decision based on
I-
on facts, you know.
Well, sir, I would give you facts if I had them, but I don't work for the Department of Driver Services, and those are facts that you can hire an attorney to tell you about. But I can only give you the explanation as I know it to be, to kind of give you the information about procedure as I would anybody else. But I can't advise you as to how many points are associated with any offense because I don't know those things.
Okay. So in terms of the I understand this is a bench trial, and I had requested a jury trial, I believe,
Okay,
to
we'll
be.
move you to the jury trial calendar if that's what you want.
Thank you, Your Honor.
All right, so Mr. Joseph, be aware that on the trial date, if you have any witnesses, they need to be subpoenaed and ready for trial. If you have documents or pictures, those need to be available and ready for trial. If they are in a video, you want to put them on a thumb drive. If it is a picture, you want to print them out so that we can't pass around a phone to the jury. And you have to be prepared for trial on the date for trial when you're called. And trials happen in person. So you will be in the courtroom on the 3rd floor, courtroom 304 at 9151 Terra Boulevard on the date for your jury trial.
And my honor, is my understanding correct that the officer would have to demonstrate evidence of mine going through that
It is the state's burden to prove the case against you beyond a reasonable doubt. I do not direct the state as to how they will present their case. I do not direct them as to which witnesses they will call. If there are some witnesses you believe need to be present, then you need to subpoena them and have them present.
Okay, thank you.
All right, so that concludes the bench trial calendar. We'll move Mr. Joseph's case to the next available jury trial.
Thank you, Your Honor.
All
And
right.
Officer Kearney, you're excused. Thank you.
Thank
Thank
you.
you,
Have
Dr.
a great
Kearney.
day.
Good to see you.
Yes, ma'am. And happy belated birthday.
How those girls?
Just very
They doing
quickly,
good.
what's the name of the officer?
Officer Kearney, Curney.
Curney. Thank you, Judge.
You're
And
welcome.
happy birthday.
Thank you. All right. So the next case, the next calendar is for this SSD. That is the 1 p.m. calendar. Ladies and gentlemen, if you are coming in for the 1 p.m. calendar, we'll get started. I don't see very many people on, so I'm just waiting for folk to come in. I will take a break until about 1:10, and we'll be back.
Yes, sir.
One o'clock. What's that?
Cyrus, investigator.
What's that?
Tyler.
Good point.
Okay.
Good afternoon, ladies and gentlemen. This is a 1 p.m. calendar for suspended sentence division. I'm Judge Tammy Long Hayward. This is the State Court of Clayton County, Georgia, courtroom 304. So this is the sentence, this is the calendar where you have concluded your case previously. You were given time to pay. You did not pay as scheduled. So these cases are before the court. If you are here to ask for additional time to complete your payment, the court will consider your request. If you are on this calendar and nobody appears to answer the calendar, the court will enter an immediate arrest warrant, and that arrest warrant will be carried out. If you can pay before the arrest warrant is carried out, then the court will be able to cancel the arrest warrant. However, if you fail to pay, you will be arrested and appear before the court from the Clayton County Jail. So the first case on the calendar, as soon as I call the calendar, I'm going to allow you to speak with the staff attorney for my office, Ms. Powell. Ms. Powell will discuss with you a possible modification of your case, and then I'll come back on and we'll conclude. So Anthony Edward Boston Jr. Anthony Edward Boston Jr. Last call for Anthony Edward Boston Jr. An arrest warrant will issue. Princess Aaliyah McCray, Princess Aaliyah McCray. Last call for Princess Aaliyah McCray. All right, an arrest warrant will issue. Next is Indonesia Tanian Chapman. Indonesia Chapman. Last call for Chapman, Indonesia Chapman. An arrest warrant will issue. Shamisia Shante Green, paid in full. Jamar Deron Hartley Cook. Jamar Deron Hartley Cook. Last call for Jamar Deron Hartley Cook. An arrest warrant will issue. Denzel Hopkins.
He's paid in full, Judge.
All right, Denzel Hopkins, paid in full. Free to go at this time. Takori Johnson, modification. Is that correct, Ms. Powell?
Yes, ma'am,
I
but a
got a
separate
question on that.
Oh, go yes, ma'am. Yes, ma'am.
Okay, so we're gonna modify both his cases. The one he's arrested for, he had an arrest order. He was supposed to appear today, but he's already in jail. So you're gonna give him credit for time served for this one today, plus the one he's arrested for, correct?
Yeah, make sure both of those are on the order, because I didn't realize there were two, but he's been in there long enough to cover both.
Yes. Okay, I told Kiara just submit two orders with two different case numbers stating one credit for time served and one, modified to suspend.
All right. So ladies and gentlemen, that's an example. Mr. Johnson failed to pay. He was arrested. The court has given him a modification of credit for time served in lieu of the amount. All right.
Hey, Judge. Sorry to interrupt. I was on mute when you were talking. My name is Denzel Hopkins, and
you paid in full. You're free to go.
I did. I think I actually overpaid. So I think it was my total fine was 153, but it was paid twice. So I think
so if you contact the clerk's office, if they verify an overpayment, they'll refund it.
Okay, sounds good.
So that's state court clerk for Clayton County.
Okay.
All right. And if you contact their office and explain what happened, you can even come into 9151 Terra Boulevard. You'll come to the first floor.
I can't come in. I live 1,000 miles away. So
okay. So you can contact them if you Google the state court clerk, Clayton County. The clerk's name is also Tiki, Tiki Brown.
Okay.
All right. So once you get in touch with the office, just go ahead and let them know what happened and they'll walk through it with you.
Okay, sounds good. Thank you.
All right. Thank you, sir. Latanya Nicole Milner. Latanya Nicole Milner. Latanya Nicole Milner. Miss Powell, let's talk about this one.
Yes, ma'am.
All right. All right. Shanquise Porche Murray, paid in full. Misael Rodarte. Misael Rodarte.
Here.
All right. Necesito interpretar.
Yes, please.
Miss Val.
Okay, Madam Judge.
Thank you. On un momento.
Okay.
All right. All right, next is Tyra Tennille Farida Salas. All right. So hold on, ma'am, and as soon as Miss Powell is available, she'll speak with you about a possible modification of your case, okay? All right. Bryant Calvin Wilkins. Bryant Calvin Wilkins. Bryant Calvin Wilkins. All right, Miss Powell, let's talk about this one.
Yes, ma'am.
All right. Alexis Linshay Williams. Alexis Linshay Williams. Alexis Linshay Williams. Arrest warrant will issue. Shannon Montia Williams. Shannon Montia Williams. Last call for Shannon Montia Williams. Arrest warrant will issue. Terrell S. Wood. Terrell S. Wood. Last call for Terrell Wood. An arrest warrant will issue. All right, so to confirm the calendar, Boston is an arrest warrant. McCray, arrest warrant. Chapman, arrest warrant. Green, paid in full. Hartley Cook, arrest warrant. Hopkins, paid in full. Johnson, modification. Milner, we're going to talk about that one. Murray, paid in full. Rodarte is present, needs an interpreter. Salas is present in the courtroom. Wilkins, we'll talk about that one. Williams, A, arrest warrant. Williams, C, arrest warrant. Wood, arrest warrant. All right, so Miss Salas, come on up to the computer.
Okay.
All right, so I'm going to put you in a breakout room with Miss Powell. Miss Powell, when you're done speaking with Miss Salas, just go ahead and give me the report, and maybe by that that time we'll have Miss Bermudez or Miss Tolles here to assist Mr. Rodarte.
Yes, ma'am.
And I just have a brief request. I know this is a suspended sentence. The state is present. I'm just wondering if I can just step away briefly.
Yes, ma'am. That's fine.
Thank you.
Okay. All right. So breakout room number 1 is courtroom and Miss Powell.
Your Honor, may I also step away briefly?
Yes.
Thank you.
All right. Courtroom can go into breakout room number 1. Is there a deputy in the courtroom? Okay, right.
Okay, Judge, we are back, and the report is that Ms. Salas is going to take the additional time to make her payment.
All right. So Ms. Salas, this is the last modification that you will receive from the court. If you fail to pay within the time allotted, then an arrest warrant will issue. Please, you'll check your email for the modification, but you understand what you and Ms. Powell discussed. You can pay in person. After you miss your SSD deadline, you lose the ability to pay online or by phone, but you can pay in person on the second floor at the traffic court window. And if you wish, you can make a partial payment or a full payment today.
Okay, full payment.
All right. So when you go down to the traffic court window, you can do that now. And if you come back into court, we'll mark you paid in full.
I don't get paid till the 20th, so I thought we was gonna do the 23rd.
That's fine. That's fine. Okay. So as soon as it's received, then we'll be done.
Am I gonna have this a paper with this information on it?
No, we'll get a report.
Okay, thank you.
You're welcome.
Hey, Judge.
Yes.
I've been trying to contact them, and I keep getting like the runaround. Do you have a direct number to the traffic division where I can request my refund?
If I'm gonna talk to them, I like send a text message. I mean, I send an email. But they are probably all in court right now. So the best time to reach them is probably maybe about 3:30, 4 o'clock p.m. Because I think by then most of the courtrooms are shut down.
Okay. They gave me a number. And I'm sorry, I'm doing this. They gave me a number, but then when I go through the automated message, I click one to talk to somebody, and it gives me like a number like in the billions that I have no idea, and it doesn't allow me to like leave a message or anything like that.
All right, Ms. Rivadeneira, do you have any assistance for him?
Okay.
I don't.
She just put, she just put the same number I called, and then they gave me a different number to call. So okay.
Yes, Your Honor, I do have the supervisor's direct number for the traffic division. She would probably be the best person to contact in reference to this. But the supervisor in the traffic division, her name is Tiffany Jones, and her direct number is
Wait. Send it by chat, please.
Oh, okay. Yes, Your Honor, I'll send it now.
Thank you. All right. So we're still waiting for the interpreter for Mr. Rodarte.
He should be on in a second, Judge.
All right. Señor Rodarte, el intérprete, estará aquí pronto.
Ok, gracias.
Sí. Hi, Ms. Bermudez. Ms. Bermudez, we have Mr. Rodarte, Misael Rodarte on the SSD calendar. Mr. Rodarte owes $151.50.
Ajá.
$151.50.
Ok.
Okay.
All right, sir, you have the opportunity to have a 2-week extension of time to pay. If you do not pay within that 2 weeks, an arrest warrant may issue.
Usted va a tener la oportunidad de tener 2 semanas más para pagar, y si usted no paga dentro de esas 2 semanas, se ejecutaría una orden de arresto en su contra.
Ok, mira, a mí el plazo que me dieron, yo traté de pagar, pero cuando yo me dijeron que me iba a mandar un papel para ir a pagar, ¿verdad? Y yo lo estuve esperando y nunca me llegó. Entonces, dos o 3 días antes de la fecha para pagar, yo llamé y me dijeron que el caso estaba cerrado, que no había que pagar nada.
Un momentito. Okay, so the time that I was given to pay, I was also told that I was going to get some paperwork to make the payment, and I never got the paperwork. And a couple of days before the due date, I called, and they told me that the case was closed and I had to pay anything.
Well, the case is closed. It is not an active case anymore, but you do have an outstanding fine of $151.50.
El caso sí está cerrado, o sea que el caso ya no está abierto. Usted sí tiene una multa, la cual usted todavía debe pagar, y esto es de $151.50.
Okay,
the fine was due on February 13th of 2025.
La fecha límite para pagarlo era el 13 de febrero del 2025.
Sí, pues fue cuando yo digo que yo llamé antes, como el 11 para eso, y todavía de hecho el día 12 fui ahí personalmente, ahí a la cárcel de Clayton a preguntar acerca de todo eso que había que pagar y me dijeron que no, pues que no había que pagar nada, que ya estaba todo terminado, no sé qué pasó. Pero yo sí traté de pagar, yo traté de ir a pagar y todo, pues.
Un momentito. I tried and pay, and that's what I'm saying that I called, I think it was on the 11th, and then on the 12th, I went to the jail, and they told me that the case was closed and everything was good, that I didn't have to pay anything, but I tried to pay.
Sir, the clerk's office would have had to provide you the information. The jail would not know the information that you need.
Señor, la oficina del actuario, o sea, el clerk's office, era la oficina que le hubiera podido dar la información que usted necesitaba, porque la cárcel no hubiera sabido nada de eso.
I can give you 2 weeks to pay, and you can make the payment within those 2 weeks. at 9151 Terra Boulevard in the Justice Center on the second floor.
Yo le puedo dar 2 semanas para pagarlo, no tiene que pagar en esas 2 semanas y tiene que estar a 91 Sara Boulevard.
¿Me puedes repetir y qué? ¿Cómo puedo pagar? O sea, porque a veces ando pues trabajando fuera, no sé si pueda pagar con hablar algún número, pagar tarjeta, money order, no sé.
Señor, esperen un momentito. La dirección es la 9151 Sara Boulevard. Es en el Centro de Justicia, o sea, en el Justice Center. Y tiene que ir al segundo piso a hacer el pago.
¿Al segundo piso?
Sí, donde dice Clerk's Office.
Ok.
Your Honor, the second floor and traffic court or
traffic court.
Es donde dice traffic court, perdón.
Ok, y solamente tiene que ser pagar ahí personalmente, no puede ser de otra forma, pregunto.
My question is, do I have to go there in person? I cannot use any other way to pay?
Because the payment is late, yes, the in-person payment is the method now.
Por el hecho de que el pago ya está tardío, sí, yendo en persona es la única forma.
Ok, sí está bien porque pues digo como trabajo fuera, no sé, pero está bien.
Okay, yes, because I work outside the state. I wanted to know, but it's fine.
Somebody can pay it for you as long as they know that to ask for your name and tell them that they wish to pay
Okay.
the fines and fees for your name. I don't think that's a problem. They'll accept the payment.
Oh, okay.
So it doesn't have to be you, but it has to be paid in person.
Yo no creo que sería ningún problema si alguna otra persona lo paga. Y darles su nombre y decirles que ellos tienen que pagar las tarifas más los que paguen.
Okay, okay, está bien.
Last thing, Mr. Rodarte, I need your email address so that we can send you a copy of the modification form.
Lo último, señor Rodarte, es que yo necesito su correo electrónico para enviarle una orden modificada.
Okay, dame un momento.
Just 1 second. And Your Honor, what the interpreter said before, Mr. Rodarte, was just to be for a moment, because the interpreter was trying to interpret what Your Honor had just said, and Mr. Rodarte just continued.
Okay.
Okay, ¿te dicto el correo electrónico o cómo?
Deme el correo electrónico, señor Correa.
Va a ser M de Mary, I de Igloo, A de Apple, B de burro, R de Romeo, A de Apple, H de jamón, A de Apple, M de manzana.
Me dijo M, I.
M-I, A, B, B de burro, R-A-H-A-M.
Ajá.
12.am a gmail.com.
Ok, le voy a deletreárselo. M-I-A-B-R-A-H-A-M de Manuel. El número 1, el número 2, punto A-M de Manuel, @gmail.com.
Sí.
Okay.
¿Quieres que lo escriba aquí en el chat?
Your Honor, he's asking.
Yes, he can put it in the chat. That's fine. If you put it in the chat, direct it to Miss Kiera Powell.
Lo puede enviar en
Just sent the message over.
Okay, thank you.
Thank you.
I received it. Thank
All right. All right, so then if you'll pay within the 2 weeks, Mr. Rodarte, you'll be fine.
Si usted lo paga dentro de esas 2 semanas, entonces todo está bien.
Ok, está bien, perfecto.
Okay, that's fine, perfect.
Thank you. All right, at this time, that concludes the calendar, the 2 p.m. calendar for the 1 p.m. calendar for SSD. The 2 p.m. calendar, we have 2 of those. We'll be starting the 2 p.m. calendar right about 2:05 and make sure everybody has an opportunity to get into the electronic courtroom. So Ms. Bermudez, that is all we have right now. I'm not sure if there's anyone on either of those calendars who may need you, but we will call you if we need you.
And, unless you want me to check back in at the 2:05.
That would be fine. Thank you.
Thank you.
All right, take care. All right, court is in recess until 2:05.
Está bien ya. Lo bueno que cualquiera puede ir a pagar, dije, bueno.
Charge of your financial life. For more money saving tips and resources, visit bettermoneyhabits.com. Bank of America NA, member FDIC, equal opportunity lender.
Ahí en el lugar que te lo dé. ¿Ah? Y a la cara como era también te compro la cara ¿no? Que no vaya a ¿ah?
All right, ladies and gentlemen, this is the State Court of Clayton County. Is the courtroom open? They should, let me see the courtroom. This is the 2 p.m. calendar. Well, there are two 2 p.m. calendars. Okay, so ladies and gentlemen, do not freak out if you don't hear your name called. You may be on the other calendar. I will indicate when I'm moving from one calendar to the other. So the first calendar we are going to deal with today is the bond forfeiture calendar. The bond forfeiture calendar. And this is State Court of Clayton County, courtroom 304. When I call the bond forfeiture calendar, if you are here for that calendar, fine. But generally, a lot of the announcements will be made by the attorney's president. So if you hear your name, though, please let me know that you're here, and then we'll tell you what we expect. All right, the first name on the calendar is Fatima S. Bright. That case is closed. Fatima Bright, case closed. Next case on the bond forfeiture calendar is Stacy William Clark. Stacy William Clark. The bench
Your Honor,
warrant was, yes,
I have it that the bench warrant was recalled and it was placed on another calendar.
yes. So I have Mr. Clark will be appearing on another calendar, and the bench warrant was recalled. Okay, next is Art Lee Duncan Tell. Art Lee Duncan Tell. Mr. Duncan Tell is wanted and a surety, a consent order was granted. Next is Antoine Bernard Eberhardt. That case was closed. Antoine Bernard Eberhardt, closed.
Your Honor,
Next, yes.
I'm sorry, that's for Goodman. I apologize.
All right, next case is Anthony Robert Godwin. Anthony Robert Godwin. I have that forfeiture of recognizance has been filed. Godwin, Anthony Robert Godwin. All right, Mr. Godwin is wanted.
Your
Any
Honor,
announcement? Go ahead.
State's requesting a rule absolute.
Rule absolute will be granted. Next is Sanchez Ingram. Sanchez Ingram. Mr. Ingram is wanted. Forfeiture of recognizance has been filed.
State's requesting a rule absolute.
Rule absolute will be granted. Derek Dion Jones. The surety consent motion was granted in Derek Dion Jones. All right. Next is Marbil Javier Molina. Marbil Javier Molina, and Mr. Molina's case is closed. Okay, Zoe Tyler Ashlyn Moses. Zoe Tyler Ashlyn Moses.
Your Honor, that case is a OTB and is placed on the pretrial status calendar, June 30th at 10 a.m.
All right. So, Miss, I do not think that there is a bench warrant out for Miss Moses. This is status check. So she's on a pretrial status calendar for June 30th. She's with the law firm of Lister, Holt, and Dennis. All right. Eric Nolasco Lagos. Wanted, Eric Nolasco Lagos.
Your Honor, the state is requesting a rule absolute.
Rule absolute will be granted. LaCage Peters. LaCage Peters. Wanted.
Your Honor, the state is requesting a rule absolute.
Rule absolute will be granted. Lorena Tapia. Lorena Tapia.
Your Honor, that case was closed on 6/3/2025.
Case closed.
A will be submitted, Your Honor.
All right. Jonathan Vasquez. Jonathan Vasquez.
Your Honor, that case was closed on February the 18th, 2025.
All right, case closed. All right, Lashana Williams, wanted, Lashana Williams.
Your Honor, the surety consent order was filed on that case.
All right, thank you. Raymond Eugene Willis, I have that a surety was filed, Raymond Eugene Willis.
Yeah.
Mr. Willis, you're present?
Yes, ma'am.
All right, so Mr. Jones, why didn't you tell me you were here? Mr. Jones? So Mr. Jones is on the calendar. Mr. Jones? We have a court date for Derek Dion Jones.
Yes, ma'am. Hello.
Hold on, Mr. Jones. We need a court date for Mr. Jones because he needs to be present with and talk to his attorneys.
Your Honor, he's on the jury trial calendar for June 23rd, 2025 at 10 a.m.
Okay. Mr. Jones? Mr. Jones? Mr. Jones, do you hear me? All right. Can we see if Mr. Jones? Yeah, you're on your next.
Can y'all hear me?
I hear you now, Mr. Jones. Mr. Jones, you are on a calendar on June 23rd of 2025 at 10 a.m. Okay?
Yeah, ma'am.
You're gonna come back into court.
She said a jury trial?
You're on a jury calendar. Okay? At 10 a.m. on June 23rd.
Yeah,
You're gonna come to court the same way by video.
okay, yeah, ma'am.
All right, thank you. That's a status calendar, correct, Miss? No, is it a trial calendar?
Jury trial calendar, yes, Your Honor.
No, Mr. Jones, you have to come into court. You have to come into the courtroom, okay? Mr. Jones?
Yes, ma'am.
On June 23rd, come into the courthouse, into courtroom 304.
Yes, ma'am.
And you'll be able to talk with your attorney, okay? Your attorney's
ma'am.
gonna be there. All right, Mr. Jones, you're free to go at this time.
Thank you so much.
All right, Mr. Willis.
Yes, ma'am.
Okay, do we have a date for Mr. Willis?
I don't see a date on the calendar, Your Honor. The only date that I would have seen would have been his bond forfeiture when he was on a previous calendar.
All right, Miss Val, Miss Rivadeneira, do we have a date for Mr. Willis? Because I don't want him to leave without knowing what his next court date is.
Your Honor, it appears that he missed his arraignment calendar. It doesn't seem like he's been arraigned. So it seems like his case should go on an arraignment calendar. We can definitely schedule that. Did you have a preference for which month, Your Honor?
Yeah, let's put him on the July arraignment calendar.
Okay.
Whichever is whichever day is available.
Would July 10th work, Your Honor?
That will be fine.
Okay. There's 10, 11, and 1 o'clock.
10 a.m.
Okay. All right, yes, Your Honor. This case has been, or is that not the correct calendar?
I'm sorry, this is Mr. Willis Raymond, Raymon, Eugene Willis, case 2021 CR 08692.
Okay, Your Honor. His case has been scheduled for July 10th at 10 a.m.
Thank you so much. So, Mr. Willis, you may get notice, but even if you don't, your next court date is July 10, 2025 at 10 a.m. And you can come in by video.
By video?
Yeah, you can do just what you're doing now.
Okay.
It's the same sign-in and everything.
That's good. You dismissed. Okay.
All right? You need anything else from me?
Am I dismissed? That's it.
Yeah, you're dismissed, sir. We'll see you then.
Okay. Thank you.
All right, you're welcome.
Bye.
So, Bright closed, Clark, the bench warrant set aside, Duncan, Tell, Surety, Eberhart closed, Godwin, rule absolute, Ingram, rule absolute, Jones, Surety, and Mr. Jones has been, is scheduled for the June 23rd calendar. Molina closed, Moses, that is a status calendar, and they have their next court date. Nolasco Lagos is a rule absolute, Peters, rule absolute, Tapia, closed, Vasquez closed, Williams surety, Willis surety, and has been scheduled for his next court date. So that concludes the bond forfeiture calendar. Red light calendar. Ladies and gentlemen, this is an appeals calendar. You have received a civil red light citation or a crossing guard citation, and you are here to appeal that citation. The first thing that's going to happen is I'm going to call the calendar to see who is here. If you are here, you will have the opportunity to speak with the state to discuss the calendar and talk about what happened and why you feel that you should not be assessed a fine for either a school bus calendar or a red light calendar. All right. Once you have spoken with the state, if you are unable to reach an agreement, then the court will review the video and make a determination of whether you need to pay the fines and fees or whether I will grant the appeal. Okay, so you're going to first, I'm going to call the calendar. Second, you're going to speak with the state. Third, if you cannot reach an agreement with the state, then you will talk to me and we will review the video and have a hearing. All right, I'm going to call the calendar at this time. First calendar on first case on the red light calendar is Ashley LaQuay Colton. Ashley Colton.
I'm here.
All right, Ms. Colton is present by video. Jean-Marie Delarme. I'm sorry, Jean-Marie Delarme. All right, Mr. Delarme is in the courtroom. Perkins Door.
Your Honor, that case has been continued to September 15th.
Okay, thank you. All right, next case is Andre Earl Lamar Ford. Andre Earl Lamar Ford. Andre Earl Lamar Ford. All right, this is a second notice for Mr. Ford.
Your Honor, they would request the appeal be denied.
All right, the appeal is denied. All right, the next case is Tanisha Humphreys. Tanisha Humphreys.
Your Honor, there's not been a response. They would request that the appeal be denied.
All right, last call for Tanisha Humphreys. This is her second notice. The appeal will be denied. All right, next is Marcus George Kelly. Marcus George Kelly. All right, Mr. Kelly's in the courtroom. All right, Denasia Kamaya Morris. Denasia Kamaya Morris. All right, is Ms. Morris in the courtroom? Okay. Next is Amanda Lynn Stodhill. Amanda Lynn Stodhill. All right, courtroom. And that is the last person on the red light calendar. So let me indicate who's answered. Colton by video. Delarme in the courtroom. Door continued. Ford case appeal denied. Humphreys appeal denied. Kelly courtroom. Morris courtroom. Stodhill courtroom. Mr. Tipton, Ms. Ponder, what is your question?
Your Honor, I'll be handling the entirety of this calendar by myself.
Okay, so you want to head to the courtroom first?
I'd rather go ahead and get the young lady who is on the Zoom calendar done, if that's all right.
No problem. I'm putting Miss Ashley Colton in breakout room number 2. Putting Mr. Tipton in breakout room number 2. Let me know when you have an announcement.
Thank you, Your Honor.
All right, ladies and gentlemen, Mr. Tipton will be coming down to the courtroom to speak with you individually. So just be patient and he'll be there in a little bit. Ms. Bermudez, I think that you have assisted us to all we need today. Thank you so much.
Yes, ma'am. Thank you. Have a good day.
You too. Take care.
Thank you.
Your Honor, I have an announcement with regard to the Colton case.
Yes, sir.
Your Honor, that's going to be a hearing.
All right. All right, sir. If you'll head down to the courtroom, then we'll do everything. We'll do all the hearings together if there are any more.
Yes, Your Honor. Thank you.
All right. Thank you.
Your Honor, I have some announcements.
Yes, Mr. Tipton?
Your Honor, position 1, Ms. Colton, she will pay the fine.
Okay.
Mr. Dellerme, he had some issues. He's going to come back at the end of the courtroom. He had to step out to the hallway. He has some issues he had to handle.
Okay.
Marcus Kelly will pay the fine.
Okay.
And let's see. It says Morris, but it's actually Korn, who's another person registered to the vehicle. She wants a hearing, and so does Miss Stodgel.
Okay.
Miss Stodgel is a school zone speeding, and Miss Korn is a crossing guard.
All right. Okay, so the Ms. Colton is gonna pay the fine, is that correct?
Yes, Your Honor.
Do you have email addresses for Colton, and Kelly?
No, Your Honor. I can get one from Kelly though, and Colton as well. One of those things with Zoom. Still used to it.
Ms. Colton, do you know how to use the chat function?
Yes, ma'am.
All right, can you chat your email address to Mr. Tipton so that we can send the order?
Okay, and I have 60 days to pay it?
I can give you 90 days to pay.
Okay, thank you.
All right, just don't forget to pay, okay?
I'm not.
All right, thank you.
You're welcome.
All right, and then when you get an opportunity to go back to the courtroom, we'll need the email addresses for the remaining people in the courtroom and Mr. Delorme's case.
Yes, Your Honor.
All right, so I'm ready on the hearings for you said the Quan?
So it's going to be it says Denasia Morris, but it's actually Miss Denasia Korn is her.
Okay.
Yeah. So her last name's actually Korn, and I've got her. I've got her already pulled up, and I've also got and then Miss Amanda Stodgel is the other person who would like a hearing.
All right, so Ms. Korn, Ms. Stodgel, you can come on up to the computer so you can see better. All right, and Mr. Tipton, whenever you're ready to share screen.
Yes, Your Honor. I'll start with Miss Korn. Can the court see? Is the court able to see, Your Honor?
I see it.
Thank you. Playing now. Was the court able to see?
Yeah, play it again for me.
Sure. Time's out.
Do we know what time of day this was? Okay, 6:36 a.m.
Yes, Your Honor.
And it was, okay. One more time for me.
Yes, Your Honor.
All right, Ms. Korn, tell me what you were thinking when this happened. What was going on?
She had pulled it in and then pulled it back out. So.
You mean she pulled over and then pulled out and pulled over again?
No, she in and then pulled it back out.
The stop sign?
Yes.
Like how long did she be like, were you stopped at some point and then she pulled the signs back and you started again?
Yes.
Where did you stop?
It was right before, it was like I was slowing down, but then after she pulled it back in, I just kept on. And then she pulled it back out.
So are you saying you just slowed down?
I have a witness in the courtroom. My mom actually worked for Clayton County Schools, so she was in the car. I was taking her to work.
Okay. So you're going to work, you see the bus is pulled over, it's raining, you see the stop sign come out, go back in, and then come out and stay out. Am I understanding?
I was already passing by that point, so I mean I wasn't finna break and then.
No, just listen to my question. So you're coming, you see the bus pull over.
Well, she didn't pull. She was on the main road. She didn't.
Okay, so she was in traffic. Did you slow down?
Yes.
Okay, and when you slowed down and you were waiting for the arm to come out, arm starts coming out, what happened?
She pulled it back in and then she pulled it out again, so I kept going.
Okay. All right. Anything, Mr. Tipton?
Your Honor, review on the floor.
Okay. So, Ms. Korn, I'm gonna go ahead and grant the appeal.
Okay.
But please be careful. I know it's kind of hard to judge what they're gonna do. Like I've had them pull over and then I'm sitting there waiting and then they'll wave me around and I'm like scared to go. But that has happened to me as a parent taking my child to school. So I understand that, sometimes they don't always follow the plan that we're expecting. So at this time, I'm gonna go ahead and grant the appeal. And you're free to go, okay? Please be careful.
Thank you.
You're welcome. All right, next for Sajil.
Yes, Your Honor, I'm pulling it up now. All right, Your Honor, I'm ready to hear.
Go ahead.
Okay. Does Your Honor also wish to see the still images?
Okay, Mr. Tipton, what am I looking for here?
It's just the video of the school bus of the not school bus of the school zone of the person driving in the school zone. They
Okay.
are the defendant is
The red car?
yes, Your Honor.
All right, start it again. Okay, and what's this? Ooh, yeah, what's the speed? That's on 138 Spur, right?
No,
Yes,
ma'am.
Your
It's 138, not Spur.
Yeah, right past what's that? Not Stillwell Elementary. It's
Went?
yes, Swint Elementary. I know that route because my kid went to Calway. And I did that every morning. So okay, the speed limit at that location is, I believe, 25 miles an hour during the school zone. Is that correct, Mr. Tipton?
Yes, Your Honor, and this occurred at 7:59 a.m.
Oh yeah. All right. So Ms. Stagel, what was going on?
Your Honor, I have video proof that the flashing lights go off at 7:58 on both sides.
At 7:58?
Yes, ma'am. They go off at 7:58 on both sides. So the side, because I just recently got multiple tickets. I go through 5 school zones every morning. So my kids go to Lake Ridge Elementary, and this is right by my house. That's
Right.
and right here, I'm taking my oldest daughter back to Riverdale High School. But in this video that I have, you can see that on both sides, there's no, you see it just says school limit, a school zone. It doesn't have like the times on which you need to slow down or do the 25. So when we were at this one, it went off at 7:58 on both sides, the time. So it's not flashing at 7:59 when I get to this red light.
Okay, what speed was she clocked at, Mr. Tipton?
48 miles per hour, Your Honor.
And when it's not a school zone, it's 45.
What's the speed when it's not a school zone, Mr. Tipton?
Your Honor, if I may have a moment, I'll look that up right now.
Yeah, because usually if it's a speed zone and it goes down to 25, the not a speed zone speed is usually about 35 to 40. But if it is 45, it's
It could be 40. I'm not exactly sure, but I know when it's not a school zone, it's 40 to 45.
And I'm sorry, Miss Stodgel, what high did you say this was near Riverdale High School?
This is Swint Elementary, SWINT.
Yes, ma'am.
Yep, right as you turn right.
So North Avenue is where I am. That's where I'm coming from. That's where the first pair of flashing lights is.
Okay, so she's coming down North Avenue, and it's right. It looks like it's crossing right in front of Crown Way towards Swint. I think you have to pull back because the flashing light starts backward on North Avenue, right at almost at that light where Crown Way is.
Yes, ma'am, it is the light.
Yeah, I'm very familiar with this intersection.
Yes, ma'am, me too. I go through it every morning. I go back and forth. I take my little kids, and then I come back and I take my oldest daughter. So I go, and then I go through their school zones as well.
Yeah, as a mama, you get to the point where you try and minimize the school zones that you have to drive through to get to the various schools.
Unfortunately, there's no way around it. So I have to just make sure that I'm always doing 25 when I go through the school zones.
And I'm sorry, Your Honor, you were trying to.
I'm just trying to see where the speed, yeah, that's when flashing. But what's the speed when it's not?
The speed limit on the street is what she's trying to find.
Yeah.
There's one a little further on.
Okay, Mr. Tipton, if it's this hard for us to determine what the non-flashing light speed limit is, I'm gonna go ahead and grant the appeal. Ms. Stodgel, just be careful, okay?
Thank you.
You're welcome. All right, so Mr. Delarme or Delarme, are you back in the courtroom, sir?
I'll go grab him, Your Honor, and I'll get that other person's.
I'm sorry.
Your Honor, I'll go grab him and I'll get the other gentleman's email as well, Mr. Kelly's email.
Okay, thank you.
Can we go over the calendar once again, Judge? I'm sorry.
Okay, no problem. Holton, that's a fine, 90 days to pay. Delarme, we're still waiting. Door continued to September 15. Ford, appeal denied. Humphreys, appeal denied. Kelly, a fine, 90 days to pay.
Thank you so much. Have a great day.
Corn, which is also Morris on the calendar, the appeal granted. Sagil, the appeal granted.
Got it, thanks.
Thank you.
Excuse me.
Yes, ma'am.
This is Ashley. I was wondering, is I'm able to go or I need to wait?
No, Miss Ashley, as long as you've provided us with your email address, you're free to go at this time, ma'am. Just check your email. You'll have 90 days in which to pay, and you should be able to pay through the citation that you got should have instructions on how to pay.
Okay, thank you.
You're welcome.
I got up here.
So you do want to kind of hear now? Yeah. We would like it. You would also like to hear it? Okay. Pardon me, Your Honor.
Yes.
So Mr. Kelly would now like a hearing, and so would Mr. Dellerme.
Okay. See you up.
I'm gonna head back to my office, and that way we should be able to get, and I'll go ahead and tee them both up.
All right, thank you.
Your Honor, state's ready on the Kelly case.
Ready?
Yeah.
Mr. Kelly, if you could come to the podium, please.
Okay.
Your Honor, are you ready?
Yes.
Thank you. Mr. Kelly's vehicle is this vehicle right here.
Okay, the second vehicle that went by?
Yes, Your Honor.
All right. Do that one more time. Yeah, I'm gonna grant the appeal. He was too close to be able to stop when the stop sign came out.
Okay, Your Honor, thank you.
Right, and that was Mr. Kelly?
Yes, Your Honor.
All right. So Mr. Kelly, appeal granted.
Thank you.
You're welcome. Just be mindful, Mr. Kelly, when you see him pulling over, that you might need to slow down and prepare to stop. They don't always put the stop sign out, but it is a likely result of them pulling over.
Okay. Thank you.
All right. You're welcome. Next.
Did it? You might be a while. So he didn't give the this young lady, the other young lady, he did. He did. I promise you, he did. She had 5 cases. Oh, she had it. No, she had a bus. No, I'm saying that the lady did something different. The other one did it right.
Is the court ready?
I'm watching.
The only vehicle passing is the defendant's vehicle.
Okay, run it one more time. All right, so at the time the video started, the vehicle was far enough away to have stopped and the sign was already out, so the appeal is denied, and Mr. DeLorme will pay the fine.
Your Honor, I did speak to Mr. Delamy previously. He is on a fixed income, and the state was wondering what the longest amount of time the court could give Mr. Delamy to pay would be.
He's on Social Security, Your Honor, on a very fixed and low income. And we were just questioning, even without the arm being out and being daytime, he just wasn't aware, didn't really know with the bus being in the turning lane and there was no arm out. He wasn't aware of the bus on his side because he was on the opposite side. There's still no way to appeal.
Okay, the bus being on the opposite side, you still have to stop. The only way you wouldn't have to stop is if there were an obstructed median, meaning there were trees, grass, flowers, concrete barrier, some median that could not be easily crossed by a vehicle. So when you have a median right here that's just really a center turn lane, you still have to stop on the other side of the street. And at the point where the vehicle is, as it stopped right now, he's far enough back to where the stop sign is out. Even if he had stopped parallel to the stop sign, I would have still allowed the appeal. But he continued going once and the stop sign is clearly out. So I can give him up to 90 days to pay.
Is that the longest, Your Honor? Because he's $1,100 a month Social Security and his expenses. I'm helping out, and you see I'm here today, so I was just hoping we could give me
120 days.
120 days.
Yeah.
Okay, ma'am, that'll be helpful if that's what you.
All right. Thank you. All right. So, Mr. Tipton, when you give me the orders, I'll go ahead and sign those, and we can get them out to everybody by email.
Yes, Your Honor. Thank you.
All right. Thank you.
And how do we go about paying on the 120 days? The same information on the citation?
Yes, sir.
And it'll be extended for 120 days? All right.
Yes, sir.
Thank you.
All right. Thank you, sir.
Come on, Dad. All right, you too, man. You have a great disposition.
Thank you so much. Bless you. I'll see you. Okay. Thank you so much.
Come on, Dad.
All right. Anything else at this time?
Your Honor, if I may quote the gentleman from the bench trial earlier, think of the swim team.
All right. All right. Thank you, Deputy. I think that concludes all of our calendars for the day. Did you have anything for me, Mr. Deputy?
No, that was very
Okay.
very merciful. Very merciful. That was very nice of you, Judge.
I do what I can. Do what I can.
Yeah,
All
the
right.
prosecutor as well, and the prosecutor as well, because he's the one that first brought that up. I really respect that. I'm not in the courtroom a lot, but I really respect both of you for that. Mercy, grace and mercy. I love it.
Well, our team as a whole, defense, state, we all work really well together to, I guess, marry justice with mercy. So I think that's kind of like why I like this job. Everybody has good common sense.
Yeah.
All right.
I'm very impressed.
Thank you. All right, everybody take care. Thank you so much. I'm still signing and I'll try and get you